23. Yeah.
Item 1, pardon my lordship.
Yes, sir.
Ashok Mahapatra, similar order, pass this court. Ashok Kumar Mahapatra.
What you want?
Similar order, court this pass.
Similar orders are.
I will supply.
Have you shared a copy with video? Okay, order good. Convince you to complete the. Mr. Sen, this appears to be.
Let's be disposed.
Yes.
Both are.
The sentence has to be changed, na? Yes. Yes, brother.
Item 2.
Item 2, the counter affidavit has been received. 1 week time kindly be granted. Counter
If you
affidavit.
ask properly, I will give 2 weeks.
Your Lordship, the counter affidavit has been received by the OP number 124.
When it was received?
It was received on the.
We have filed in 27/10/2025 and also copy this up on
Copy
27.
has been served.
Then you have to argue. Otherwise, giving only adjournment. Why you have brought me from Bangalore here?
Your Lordship, only one time to go through the. Only one.
All right. Next week. 1 week, reluctantly granted at the request of counsel for the petition.
Published.
Yes.
I person is sleep, my lord. Different councils appear.
That's all. That's all.
Item 3.
Follow. Yes, brother. 3. That matter. So invite approved list of with the SFC in respect of higher law. You accept notice, brother? I think there is a representation also. You take that notice. The lawyer is not here.
Yes, madam. That representation has been considered and has been rejected.
You take notice. Let's issue emergency notice. Mr. Sen, he accepts notice for all OPs. Yes.
Item 4.
Yes, sister.
Lord, here the petitioner is praying for a direction to the opposite party CMC, Cuttack Municipal Corporation, to register her case for the change of her name.
Bhavyashri Bharadwaj.
Yes, my lord.
From Bhavyashri Bharadwaj to Bhavyashri Sharma.
Yes, my lord. And her mother's name, it is written as Monica Purohit, whereas her name is Sumitra Devi Sharma. It is
You have changed your mother's name also.
Yes, my lord. They are not accepted.
Any representation you have made?
No, my lord. In Annex 7, she has given application. That is returned all the application and all the requisites.
Why it returned? You take emergent notice.
Yes,
Issue emergent notice. Returnable within 2 weeks. First, immediately after service, since the matter lies in a very narrow compass.
The date may be fixed. The child is
Admission stage, if I fix date, DAS will object to that.
the child is to school now. They need a
2 weeks it will come.
Yes.
If it does not come, just mention.
yes.
You serve copy any standing counsel?
I do.
Just verify.
They have panel.
That's to take individual steps. It is open to the petitioner for counsel for the petitioner to serve copy of the petition on any panel counsel, if any. On any panel counsel, if any. Okay.
Published.
On panel counsel, if any. Okay.
Item 5.
May I please, Your Lordship? Madam, it's a rehabilitation appointment matter, Madam. The petitioner's father was working as a reader in
When he
economics.
died?
Died means 29/4/2022.
29/4/22. When did you apply?
Apply on 20th March 2023.
In time.
Madam.
They have not done anything.
No, Madam. They have not taken any decision till today.
Any representation reminder you are saying?
Yes, Madam. Annex.
Go to the first date.
7 series, page 32, Madam.
23 onwards, ma'am. Page 23 onwards.
Another dated. 1 second. Just give me the date of death.
29/4/2022. 2022.
When you applied?
20th March 2023.
20 February.
March, my lord, March. My lord, thereafter,
You have given all the papers.
all the documents I have,
And
along with the
please answer the code.
confirmation.
20 March 2023 you have applied.
My lord.
Then when did you send any representation reminder?
Then 8/10/2025, my lord.
Yes, then you have sent. Take me to that reminder.
Madam. Page 32.
32.
Madam. That is in Odia. Madam.
Very good.
Director, Department of Higher Education. Supply.
So all right. Next, apply for rehabilitation assistance scheme.
Ma'am.
Why, brother, you are keeping rehabilitation facilities in abeyance? How many cases are coming before me? Why? What the family should do? You decide this way or that way. Why are you keeping? Why do you drive a widow and children of the deceased employee to the court? Court is not a happy place. Who is the person who should take that decision?
Director Higher Education.
Kindly, Vasant. The essential prayer of the petitioner is as to long pendency of his application for appointment on compassionate ground, his father having died in harness on 29/4/2022, and he having applied for such appointment on 20 March 2023. First stop. Next paragraph. Learned counsel appearing for the petitioner submits that the apex court in a dozen judgments has warned the authorities that applications of the kind should be treated on a war footing. And despite such warning, the officers are not waking up from their deep slumber. First. Therefore, he submits, interference of the writ court is highly warranted. Next paragraph. Learned ASC Mr. Sale accepting notice for the office 123, notice to 4 having been dispensed with, submits that the legal position stated by counsel for the petitioner is true, semicolon. However, there are certain formalities to be accomplished and procedures to be followed, and therefore delay would happen. First off. Having said that, he agrees to instruct his jurisdictional clients, official clients, to look into the grievance of the petitioner immediately if a reasonable time is prescribed and all contentions are kept off. First off. With this, counsel for the petitioner quarters. First off. Next part. In the above circumstances, 6 weeks. Okay? Open to solicit information, etc. from the petitioner or any department concerned. However, in that case, delay shall not be proved. Courts are reluctantly not levied at this stage. Okay. You have copy to be acted upon.
Not a petitioner is a lady, so instead of he.
Instead of he, her. Thank you.
Item 6.
Item 6 covered, your lordship's order covered.
Dog and pension malad, they read the pending.
Subject to order of character, we can do Mr. Monty, we have done that well.
Yes, ma'am. Yesterday.
To this one line. However, this shall be subject to outcome of pending writ appeal number. Number, I will give that. Number, sorry. Pending writ appeal on the similar subject matters.
Yes.
Next.
Item 7.
Yes, sir.
My lord, here petitioner challenging the impugned order on a annex of
Voice is not audible. My voice is audible to everybody.
My lord, petitioner is challenging the impugned order passed by the opposite parties by the annexure 10 at page 36 to 42, my lord. My lord, herein petitioner who was appointed as a headmaster,
Arrears of salary to be paid to you.
my lord, not only salary,
Because your prayer cannot be understood even by Brahma. I cannot understand. What kind of prayers you are drafting in your petitions without reading one single book on the law of writs? Moga's pleadings not read, Rao's pleadings not read, Basu you do not read. Therefore, all these verbose prayers. Sorry to say this. Nobody in the right side will draft such prayers.
my lord.
What you want? First, this impugned order. Direct him to consider my prayer.
My lord, I have not been paid my salary since 2004.
You want your goats back. Direct them to give back the goats. Why all story? Goat took place this way. Goat has 2 horns, 4 legs, arguably.
My lord,
Tell him
details,
what I want. I am very strict in that.
Well-
This is not the way. Although in the Constituent Assembly, Dr. Ambedkar said the writ remedy can be granted without a prayer also. We can do that. But your prayer is so cumbersome. It puts the judge to the jiggery. I cannot understand. Issue notice, issue show cause notice. If they show cause, if they do not show cause, then you do like this. Lot of circus you want the judge to do.
my lord.
Very difficult for us. So many prayers. How much time wasted on understanding the prayer? One line prayer. Salary not paid. They are bound to pay salary. To others they have paid. There is no reason for non-payment. Direct them to pay.
My lord.
Whole story, whole origin of species, how Earth took place, how species took birth, how evolution.
My lord.
I'm fed up with you.
Initially, my lord, I was appointed as a headmaster and my post has been up.
Take notice.
My lord, already I have been retired, but I am not getting the provisional pension also. Even
Why, brother? Now first time it has come.
my lord, this is the 5th time I have come here.
Notice was issued.
Earlier, notice was issued.
First time.
There is a order, my lord.
But he's
My
saying first time. Earlier also.
My lord, in the same petitioner filed the 5th time this writ petition. Only prayer is to implement the order of the Honorable Tribunal, which has been disposed of in the year 2010. Till then, they are not implementing the order, my lord. At annexure 2, my
I
lord,
am asking the date of the order.
date of the order, my lord, 21st, 18 September 2007, I filed, and the order is 18/9/2010, my lord. At annexure 2, page 24, 22-24.
Let him take notice, brother. Let him take notice and come back. I'll call this matter next week.
My lord, my lord.
Issue emergent notice. Counsel for the petitioner submits that this is the 5th time that his client is hovering in the court corridors. First off. Come on. For seeking implementation of the Orissa Administrative Tribunal's order dated 18/9/2007.
My lord.
18/9/2007.
Yes, my lord.
18/9/2007. First off. Mr. Sen, learned AC is requested to accept notice for the OPs since matter lies in a narrow compass and multiple petitions were filed earlier. Come on, call this matter
My lord.
next week.
My lord, order is 18th September 2010.
That's what, 18/9/2010.
My lord. Order.
18/9/2010. Let us see.
Right, my lord.
I request the bar members, senior members to hold some classes for the youngsters, how to draft the petition, how the prayer should be coined. And Mr. Das and other things, they can all of you can do that, na? Or your petitions are also like that only. You will teach the same thing. Yes.
Lordship, I will say the state education tribunal, my lord. In place
State education tribunal. State education tribunal. Why tribunals orders are not implemented? This is initially 15 matters. Just verify. In one matter, I will levy cost of rupees 1 lakh. Okay. So I'm just searching for that matter. Yes.
Item 8.
Item 8 also.
Without money, nothing moves in your state. I'm sorry to say this. Without money for filing, posting orders, implementation of orders, the citizen is half dead by the time he receives the fruits of the litigation. Yes. 1 lakh rupees I will impose on the officials. I'm just putting it in as a warning. Warn them. Yes.
Item 8.
I have a case here.
And on this, no writ appeal is filed, no?
No writ appeal is pending.
No writ appeal. This word of.
Item 9.
Rightly. In this case, my lord, I am challenging the petitioner is a contract employee and is challenging the rejection order of the representation by under Annexure 9, page 45. Dated 29/2025, my representation for my transfer on the ground of my illness of my father was rejected. Though I put a representation to the collector of Bargad, and my lords under earlier I approached this honorable court, and at page 43 my lord directed.
What is the disease of your father?
My lord, disease. I have annexed all the documents. He's a
no, tell me the disease.
yes,
Then
he's a heart patient. So also,
what kind of heart patient?
my lord, I
Heart
have
disease?
yes, I have annexed the document.
Show that.
Is
How many children your father has?
I am the only son, my lord.
Only
I have taken that plea. That is why reason, my lord, after transfer, I was immediately relieved. I joined the post. Thereafter, I was bound to take. I am on leave now. So now my lords, I have put the representation to the collector, the DEO, District Education Officer, under Annexure 9, said that I am competent to dispose of the representation, and he has rejected the representation.
Who is
Let
the-
me kindly see Annexure 9.
Who is the competent authority?
Actually, the competent authority is the director,
Director, not
Yes.
BEO.
not DO. DO, actually, collector has passed the earlier order. I put the representation to the collector. My lords also directed the collector to take a decision.
Not some other.
DO was not, yes.
Why, brother?
And against that, under the instruction,
Accept notice and call this next week. All blind people working, what to do? They should issue an emergent notice. Returnable within 1 week. First up, learned ASC, Mr. Sen accepts notice for, is requested to accept notice for OPs. First up, short point is involved as to jurisdiction and competence, which can be ascertained in minutes. First, call this matter next week.
Directed to Annexure 6 has been considered.
After this, one personal appearance. Yeah, he said copies. Next week, brother, I may impose 25,000 in this. Just let. I am putting you in warning, which I will do. As you know, you warn your officers. If they don't do it next time, he cannot go empty-handed. I have to give him an order, and I have to give something to his purse also. Direction is to the district collector. But anyway, you'll just look into it. Prima facie, it appears that way. Order is passed by some other authority, whom I never directed to take a decision. Yeah.
Also directed to dispose of the representation Annexure 6, madam.
Fix is given to who? District collector. No, that will not help disposing of application. That helps me to increase the number of disposal. But justice will not happen. Now just look into
To the collector.
Yes, collector.
Come chairman Samagra Shikha Vargadman.
Yes, therefore you tell your collector. You tell your collector, next day, I will impose cost on the collector, personally payables.
Yeah, he having, my lord, there are several allegations by the teachers association.
I do not know.
And
You take, who should take the decision? The collector should take the decision. Let him, her take a decision. Yes.
But the last occasion, losses granted by to produce my
One second, there is a personal appearance.
that
I am the petitioner.
that matter.
Item 50.
Yes.
They are filing manner, your lordship granted manner, all the passbooks.
No, that principle is to.
That is the order.
Hygiene.
Kindly take me to the order which was required to be complied with.
My lord.
Why we called college people to come here?
That other college.
No.
Because they have to produce.
20th of the September, first order.
September.
Yes, thereafter 16th of October.
Principal Samantha Chandrasekhar, Institute of so and so.
Yes.
Furnished complete service book of OP number 4. Why you are called to court? We asked you to furnish the papers.
Have complicated the details, however, it needs this
Later.
that's the reason why.
Yes, you have brought the papers.
Yes, sir, I have the.
Who are you, sir, and what's your designation?
My name is Dr. T. Rajesh Madhurati. I am acting as a director of
Niche institution. Kindly be seated, Dr. Sir. Give a seat. He is not accused. He is not. Yes. Give that. Kindly be seated, Dr. Sir. Yes.
There is envelope.
No. Open the envelope.
We are also directed to produce our document.
Where are your documents?
Well, I am filing this document.
Submit to my lord.
You should serve copy on each other first, because
Yes,
you
that
have
will
to
be-
say on
yes.
those documents, not
In course of the day, copy and summary in course of the day.
I am serving, my lord. I have made it like this. With an affidavit, I am filing the photocopies. The originals are with me. Shall I file all both?
originals you can show when matter is taken up for
Yes. Then the
Affidavit-
photocopies I am filing. With
Sir,
the
I am also filing photocopies, keeping that originals with me.
Yeah, you retain your originals, but you have to show to me
Madam.
when I want to look.
Yes.
I will serve a copy on my lord senior.
Can we now say, have you received this copy?
Which one?
From the college?
No, we have not. That is.
Share that copy, give 2, 3
Otherwise-
xerox from our Xerox machine. Okay? You look into each other's version,
Then we'll come back, my lord.
then you have to come.
Yes.
And before coming back, sit across the tea table, just to show the work papers to them, what is what. It becomes easy for me.
Yes, everybody knows.
All right?
Yes.
And yesterday, when your lordship had that matter, exactly similar case.
Let us see. Let us see. The pursuant to order dated 1610.
No, 1310 is the last order.
16/10/2025. Dr. Professor So graciously appeared before this court and handed the required information in a sealed cover. First off, the copies of sealed covered contents to be furnished to learned advocates appearing for the parties to have their say over the scene. First off, this court appreciates the appearance of Dr. So. Okay, next paragraph. Learned counsel appearing for the parties also have filed certain documents
I filed with an affidavit.
supported by affidavit. You are also supported by affidavit.
No, I have brought
yes,
this.
Finished.
Yes.
I filed petitioner. I am petitioner.
What you have written now? Learned counsel. Somebody have written counsels. That's wrong word. Counsel is a plural also. Yes. Documents. After serving copies thereof on each other.
I'll solve.
Yes, not solved.
Therefore,
Yes.
it will be
All right.
each other. First one. The parties, the petitioners, counsel for the parties are requested to go through the same and come back with their version. First. All right. You supply their copies also.
Sir.
Thank you, doctor.
But the
Thank you.
other records, your lordships directed the government to produce the record.
The tribunal's record.
Tribunal
The
records, we
tribunal
wanted
record.
direct
More
postage. There is an order, no?
Yes, yes.
There is a.
Directors.
You got that original records. Director and tribunal, both. We wanted to verify.
Yes.
Well, that we have intimated them, but we have not yet received.
Not yet received.
Not yet received.
Learned,
So, but the tribunal record is concerned.
Learned PGA Mr. Mohanty submits that despite, when did you write to the,
Well, on 24th October 2025.
despite writing to the director of
This is Director of
Higher Education, on 24/10/2025, comma, for producing the original records, comma, there is no response, and thus he expresses he is helpless and seeks a short accommodation. Again, first off, on the next date of hearing, the director shall produce the original records as sought for the AGA, failing which he may be directed to pay a cost of rupees 25,000 personally.
This is tribunal.
Also tribunal. Director as well as tribunal.
Director,
As well as the
There is the
tribunal
Education Tribunal, Bhubaneswar.
in appeal number 11 of
you
18.
sent letter to whom?
Who?
You sent it to director.
No, my lord, to Director as well as the Registrar. My lord.
Director.
Yes.
Okay. Next, see. He also tells the court that he has sent a similar letter to the registrar of the
Odisha Education Tribunal.
There is no register. There is a secretary. There is a secretary.
secretary of Orissa Educational Tribunal at Bhubaneswar, and the secretary is not responding to the same. First one. What would happen to the director on the next date of hearing if the lapse occurs would happen to the secretary also? First, registry to send a copy of this order by speed post before the sunset of the day for reporting compliance. Okay.
Interim order to continue.
In the meanwhile, interim order to continue. Call this matter.
My lord, fixing it to.
Yeah, some date has to be fixed. No, otherwise they will not do anything. We'll call this in the second week of December.
My lord.
All right.
All right.
Put some date. Yes.
My lord.
That amount you send that to let me.
Today itself, I can send and.
If they see this order, they will do that. Don't worry. Otherwise, they will not answer the government advocates at all. I know that. What kind of officers are all callous people? Yes. Yes.
Item 10.
Yes, may I please?
Yes, sir.
My lord, here recovery has been directed.
Covered by a matter?
Yes. My lord, recovery has been directed after retirement from service.
That's what. You take notice from?
Yes.
Or
My lord, that personal appearance.
yes, I will take
Permission to leave.
Yes, sir. Yes, sir. Thank you so much. Okay. Sorry for the inconvenience that has happened. It appears to be covered by the judgment.
Yes.
So entire money is recovered.
My
Or
lord,
yet to be recovered.
yet to be recovered. That is 3,47,850.
Rafiq Masi. And other matter.
And the latest judgment is Yogeshwar Sahu. And your lordship judgment is also
referred to
there.
that. Na? On the issue emergent notice, case is requested to accept notice for all OPs.
All opposite.
All OPs. First. The net counsel appearing for the petitioner presses the application in IA number so and so for interim protection, citing a decision of this court.
Yes.
This court in yes.
Moti Dei.
Or you can say Supreme Court itself.
Supreme Court decision is
Yeah.
Yogeshwar Sahu.
In Jogeshwara Sahu versus District Judge. But
That is the latest decision.
correct. 2025 5 SCR 13. First, the case is made out for granting interim protection. First, next, in the above circumstances, application having been favored, recovery is interdicted till next day of interdicted during the pendency of the petition.
And my provisional pension has also been stopped since August 2025.
Next, counsel for the petitioner submits that even the payment of provisional pension also has been stopped, which is contrary to T.S. Nakara, and therefore there should be an interim direction. First, on the DS, he submits that he would confer with his client, official clients, and come back. First off, post this matter on 25th, brother.
Yes.
Why provisional pension is stopped? That you have to say. Provisional pension cannot be stopped.
Earlier granted. So
Just look it up. Next.
Item 11.
Yes, sir.
My lord, petitioner is a locomotor disabled with 90%, my lord. In the accident, he lost his two legs. But for the annexer 1, my lord, the representation that though the quality of locomotive, the limb is very low quality, that is the guideline of the government to change after 2 years. Already 5 years come, he is repeatedly submitting his grievance before the opposite party number 1, 2, but they have no response, my lord.
The government will not respond at all to the citizen. It responds only during election time.
My grievance is also pending before the opposite party number 1, my lord.
Commissioner cum secretary.
My lord. And I have also accommodated opposite 2 and 3 also, collector Dhenkanal also.
You, Mr. Monty.
The quality of artificial limbs, which is to be replaced after 2 years.
Correct.
My learned friend's submission is, being the disability, it should be a qualitative one. For that, government should provide the same. That is the summons substance. So it is
Consider
here,
that representation.
here is secretary, the OP number 1.
Petitioner's grievance is reflected in the short text of his prayer, which is as that. Next. Counsel for the petitioner draws attention of the court to the representation, to the latest representation
Yes, my lord. Annexer 1, my lord.
dated 9/8/2025. A copy whereof avails at Annexer 1, which reads as under. Next paragraph. Counsel for the petitioner submits that in terms of the constitutional mandate enacted in Article 353, as has been progressively interpreted by various high courts in the country, representation of the kind could not have been kept in limbo eternally. Personal. Learned AGA, Mr. Mohanty, on request accepting notice for the OPs, very fairly submits that he would confer with his official clients and ensure that the representation meets its weight in due course. First off, he requests the court to prescribe a reasonable period, keeping open all contentions of the parties. First off, with this, counsel for the petitioner contents. First off, next one. In the above circumstances, petition is put off 8 weeks, which will include communication of outcome of consideration to the petitioner, open to solicit information, documents from the petitioner or other jurisdictional offices as may be required. On that ground, delay shall not be brooked. At this stage, costs are very reluctantly not levied. Okay. Web copy to be acted upon.
Miller, in addition to that, Annexer 2, the contents of the same may be added. Because
Annexer 2.
Commissioner cum secretary has written letter to all the collectors.
Despite that, that has not been.
That may be added, it will be.
One paragraph. Counsel for the petitioner draws attention to the Commissioner cum Secretary's letter number 448 dated to 12/1/2020. 27.
No, my lord, it says 22.
22, my lord.
At Annexer 2, wherein
The detailed guidelines
proposals.
penultimate para, my lord.
Very
detailed guidelines.
Wherein which merits reproduction. Reproduction. First time. Thereafter, Monty said like this. Let it not be your word. Let it be his word.
I am just pointing out to have
That's all. Yeah.
visible notice issue. Kept pending.
No. Disposing of, keeping this and this one. Next level, so that I can levy heavy cost.
By that this can.
That's the reason. Yes. Item 12.
May I please? Now, this is a case, my lord. A girl student at this school, standard 8 student, found stolen of 110 rupees and she committed suicide after she was detected. The headmaster and another teacher, they were charge sheeted. FIR was lost. Criminal case was instituted. Also simultaneously, disciplinary proceeding 2011. The criminal proceeding that has been quashed. Annex 3. The cognizance has been taken by the SDJM and that has been quashed. Annex 3, page 23.
By this court.
By this court. Page 23, paragraph 10.
Correct.
So thereafter, my lord, in 2011 charge sheet, now I have prayed for quashing the disciplinary proceeding, and now they have appointed the inquiry officer.
Brother,
656.
if suppose it's unfortunate incident that the girl committed suicide, all our scriptures say, Atmahatya Mahapapam. Okay, that is one thing. But how these people are responsible? Robert Clive, who fought War of Plough with Sirajuddaulah, he founded British Empire and committed suicide. For suicide, many medical reasons are there. How can these people be held up for that? Issue emergent notice. Mohanty accepts notice for.
Let an extra copy be served.
You serve copy, extra copy, bro. One accepts notice for all OPs. You filed application.
Yes. No.
You are not filed.
No file. Not file.
But matter lays in a narrow compass. Call in the second week of December. Second week of December. Okay. Give copy. Okay. Item 13.
May it please, my lord.
Yes.
My lord, this is an application under appointment under rehabilitation scheme, my lord, under Utkal University. A similar matter already, my lord, has disposed of.
But somebody to consider your application.
Yes, my lord, to consider my application.
That application I can make without lawyer also.
In respect of Muralidhar Swai.
Do that.
Same regulation day and same appointment.
Any positive order is made. Positive order, if you want, other side has to be heard, na?
Yes, my lord.
Issue emergent notice. Who is the panel counsel?
P. Patnaik, my learned friend.
In addition to taking usual steps, counsel for the petitioner is permitted to serve copy of the petition along with all the documents on the panel counsel, who usually represents respondents 2 and 3. Okay. 1 for 1. Okay. Item 14 of the service.
May I pray for a short written?
No, how can I fix a date?
No, not about fixing date, my lord.
I said the post immediately after service.
Grateful.
Item 14.
May I please?
Yes, sir.
This matter relating to the establishment of the Anganwadi center, my lord. For last 14 years, the center was running in a rented house. So it was the requirement that in government owned property, the own building, it has to be run. For that purpose, the local people agreed to execute a gift deed. And accordingly, your lordship can have a glance to page 31. Page 31, the BDO.
Have they executed the gift deed?
Yes, your lordship.
Registered gift deed?
Yes. Page 31, there is a letter of the BDO. Written.
Why are you?
They are now taking steps to establish that Anganwadi center in a distant place. arbitrarily within that revenue village.
Consider that representation.
They are saying that they are proposing to do it in some other area, even though within that vicinity.
You just consider. Although it is for the government to decide where the school should be established, where the mortuary, where the hotel, these are governmental decisions.
Yes.
But since you have given representation, let them take a call. No representation given. You give representation.
And the land has been provided by them.
Land is provided.
That is there.
So much money you will save, which you can use for other.
Page 31 is clear. That is written by the video that that particular plot number has been indicated. That gift deed may be executed. And accordingly, that gift deed is executed in the name of the government, name of the video.
Yes, executed.
Yes, Your Lordship. Page 31 is the letter of the video, and the gift deed, that registered gift deed has annexed 2, my lord, page 11.
Short, given how many petitioners?
3 petitioners.
3 villagers are knocking at the doors of the court. Their essential grievance is that the school to be founded in
Anganwadi center.
an Anganwadi center to be founded should be established in their village, as was the impression given to them. Should the villagers give the building for that purpose? First off, so they grieve that despite transfer of property way of registered gift deed, no efforts are being made by the quarters that be to found the center elsewhere than in this village. First, the council argues that it is absolutely unfair in as much as acting on the representation of the officials, the villagers have already transferred, gifted the property for the award purpose. First, council cites the decision of Apex Court in Afghan agencies versus Indo-Afghan agencies versus so and so in support of his contention. Next paragraph. Learned AGA, Mr. Mohanty, on request appearing for the official OPs, submits that the decision as to where the Anganwadi center should be established relates to the domain of the executive, and therefore the grievance is not justiciable. First off, he also, having so contended, now he agrees to instruct his clients to look into the grievance of the petitioner in the light of the gifting of property by the villagers for the founding of the center in question. First, till a decision is taken, this decision has to be taken after hearing the village leaders. First, next, in the above circumstances, with the above observations, petition is disposed of. First, it is open to the petitioners to make appropriate representation for voicing their grievance before the jurisdictional authorities by producing necessary evidentiary material.
Along with the certified copy and the petition. We will produce everything. Yes.
Of course.
Well, may I request additional one thing? Till our representation is disposed of, no further action be taken.
Let me go there. That is very difficult because it's a question of giving education to the children.
That is continuing there. That is continuing in our village, at the rented house. They are proposing the once.
My lord, sir, observe that. Immediately will intimate it. I think this will.
The moment they will start in construction somewhere else, it will be practically it will be difficult.
Till a decision in the matter is taken in the light of what has been observed above, and also in the light of the
representation in contemplation, comma, which representation has to be submitted within 2 weeks, comma. No precipitatory steps would be taken by the officials. Okay.
I'm grateful.
Item 15.
ಅದನ್ನ ಸ್ವಲ್ಪ ನೋಡ್ಕೊಂಡು ಮಾಡ್ಬೇಕು ಸ್ವಲ್ಪ ತಾರೀಕಿಂದ ಚೇಂಜ್ ಮಾಡ್ಕೊಂಡು ಹಾಕೋಬೇಕು.
May I lordship?
Yes, sir.
My lord, this petition file I am in person and kindly allow to argue.
You have right to argue.
My lord, in this writ petition, there is a prayer for appointment against unfilled vacancy. Under Annexure 1, advertisement was issued. I am some written.
Come to your prayer.
My lord,
Prayer.
okay, everything I am mentioned here.
No, I am
in
asking
sort
you.
of route. Okay.
Read your prayer.
Okay.
If the judge says you have to read the prayer.
Okay.
Two prayers you have made.
Directed to the opposite party for his category VI and VII as the number of junior teachers, schematic post are laying vacant.
Want appointment orders. To which post?
Junior teacher schematic.
Where is the selection list?
Selection list some psychological issue and I am not competent. I am everything in of written argument.
We all have psychological issue. Don't worry about it. It is in varying degrees. Mr. Monti, just look into his grievance.
Madam, may I clarify one thing? This is all the advertisement of 2023 for the junior teacher schematic. In that particular advertisement, so far the age is concerned, it is 18 to 38.
18 to 38.
It is available on page 16 also.
What was his age?
But so far the cost title is concerned, the present petition is 45. If it is at 2025, then it will be 43 definitely at the time of advertisement.
But whether the recruitment process was notified
23
regularly?
23 regularly.
Before, no, that you have to show. Because Apex Code said, where you do not notify the recruitment process on regular basis, the period during which you should have notified should be discounted while computing the age of the candidate.
Just I am pointing out, my lord, at the threshold.
Let us see. He said that he has some problems. I was reading one recent novel, Alchemist by Paulo Coelho. He writes, so we all have our measure of madness. The only difference is those who can control it and those who cannot.
Control it.
I'll issue notice now. Let him come back. Issue emergent notice. Learned ET is requested to accept notice for 1 and 2. First off, this petition is by a party in person and matter lies in a comparatively narrow compass. First, call this matter. I will fix some date because you are party in person. All right. In the second week of December. Which date you want? Pull down a date from the calendar.
You give me any date.
December 9th is all right for you, brothers. 9th of December.
9th of December. Okay. 9. No problem.
If this is fine.
Item 16.
Yeah, please, Lord.
Yes,
the petitioner was appointed as a PET under establishment of OP number 5. To accommodate OP number 6, his service was terminated without any proceeding. Then I approached this honorable court
And subsequently, I found that the educational qualification which has been given by OP number 6 is a forced one. The inquiry, forced one. Yes. And inquiry was conducted. Ultimately, the order was passed under Annex 16 to terminate his service. As a result of which, that post is lying vacant now. My only number there. But
is it terminated?
Yes, it's been terminated. So only my Annex 17 be considered
for reinstating you.
My lord,
you want notice or you want consideration? Whichever way. Once I issue notice.
My lords, the case is that his name is not found in the
select list.
No.
It was never. Case is that he was not appointed at any point of time. So my lords may direct consideration of representation.
That's right. What my learned friend is saying is not correct.
That is disputed.
Prima facie, he is saying on the basis of the papers you have given. Unless your name figures in the select list, you cannot jump to the fray of...
Exactly. I am quite conscious of that provision. You also can turn to page 22. My name was also saying...
Short grievance of the petitioner is reflected both in the prayer column of the petition, which is as under, and in the representation, which reads as under. Petition dated
10/4.
4/4/25.
4/4/20.
At an exact. Next one. Counsel for the petitioner submits that his client will be satisfied if a direction is issued to consider the subject representation in a stipulated time period and in accordance with law. With this proposal, learned AGA, who initially opposed the petition, is now agreeable. First of all, 8 weeks. Okay?
Considering Annex 16. Annex 16 is a termination of OP number 6.
Annex 16?
60. Yes. His service was terminated.
Consideration should happen in the light of the letter number 8351 dated 1/10/2024 issued by District Education Officer Puri, at a copy whereof avails at Annex 6. Next. Item 17.
May I please? Well, this is a case of transfer. My lord, I have only 1 year, 9 months to go for my retirement. My lord, your lordship may kindly turn to Annex 3 at page 22.
Has it been relieved?
No, I have not yet been relieved. My lord, earlier I had approached this Honorable Court. This Honorable Court directed for consideration of my case. And now, by virtue of order under Annex 7, my lord, the block education officer says my earlier order was wrong. And accordingly, it has been rejected. I have been continuing in that school. And I have only 1 year, and that government notification says
issue emergent notice. Learned AGA Behra is requested to accept notice for the OPs. First, counsel for the petitioner draws attention of the courts to the application in number so and so, telling that his client has got a short stint of service for retirement, and therefore he is entitled to protection under the extant transfer guidelines dated
14/5/2025.
14/5/2025, which ordinarily protect the persons in the verge of retirement from being transferred. First, in similar matters, this court has already issued some protection orders. First, next, in the above circumstances, application having been favored, the impugned order, the subject transfer order is kept in suspended animation. First off. However, if the petitioner is already relieved,
my lord, may not indicate that. Otherwise, my lord,
they will relieve
antedate. Your lordship may say that
He may be allowed to continue in his previous place. My lords, he may continue where he is appointed.
Yes. Petitioner to continue in the place where he was
continuing. He was appointed.
He was continuing. He was continuing.
Posted,
He was posted. Very good.
He was
posted earlier.
Yes.
Next. Item 18.
This is a repetition matter, my lord. My lord, in the first case, the petitioner was appointed as a data entry operator in DDC, my lord. My lord, in similar cases, my lord the lordship has disposed of in view of and Jago and
the date of entry. No, it's a regularization.
The regulation, my lord. My lord, let the university council who is usually appearing, let them appear, and my lord, I pray thereafter it may be disposed of in light of. My lord, I am also handing over this Jago and Shripad. Yes, my lord.
Issue emergent notice, AGA for 1.
2, 3, 4 notice will go.
Emergent notice to the rest. But it is open to the petitioner to serve copies of petition along with all the documents on any panel counsel who usually represents 2, 3, 4. Yes, same order.
Yes, ma'am. Grateful.
Item 19.
In this application, the order under annexure 4 passed by the collector is not challenged.
Just 4.
Yes, madam. Here is the case is that the opposite parties filed an application for legal heir of Jaswant Singh, claiming themselves are the adopted son. And the petitioner's father was the adopted son of the Jaswant Singh. Accordingly, there was a dispute and legal heir certificate was rejected by the Tahsildar. There was preferred an appeal before the sub-collector, which was also rejected. And at the time of rejecting the appeal, the sub-collector has specifically observed that since a disputed case, the success certificate a civil suit be preferred. And accordingly, they have also filed a civil suit that is under Annex 3 before this competent court for declaring themselves they are the legal heirs. The opposite party filed this. And thereafter, they filed an application with the collector, and collector rejected dismissed set aside the order of the Tahsildar and the sub-collector and directed the Tahsildar to give issue the certificate in favor of the opposite parties, which is beyond his scope, beyond his.
Take notice.
Yes, ma'am.
Mr. Lenka issue emergent notice. Mr.
No copy is
copies to.
They will made collector parties. I'll start.
Requested to accept notice for OP numbers.
OP 1, 2, 2 OPs are there.
No, Behra appears
the private opposite parties against.
He appears for whom? Look into the cost title.
Yes, in the cost title, Ahmed party is Rajpal Singh and Gorbir Singh. But private opposite party against whom the.
But ordinarily,
state is not a party.
The collector has not made a party.
So it is actually there is one judgment of apex court which says when the quasi-judicial authorities make statutory orders, they need not be implemented. Is one view is also available. But you implead him so that I will direct you to implead now.
Yes, I'll do this.
You will do that.
I'll do this. I'll serve a copy.
That's all. Petition calls in question the order of
collector
of district collector.
Yes, under Annex 4.
Under Annex 4. However, inadvertently, the collector has not been arrayed as one of the respondents. First of all. Therefore, on the request of counsel for the petitioner, he is permitted to array the collector of district collector of
Kannavad. This is Kannavad.
Right. As OP number 3. OP number 3. First. Heard learned counsel for so the case is made out for issuance of emergent notice. First of issue emergent notice. Mr. Behra, learned DGA, accept notice for 3 and emergent notice to 1 and 2.
But a miscase is there, my lord. Stay pressure of the order of the collector.
Stay of that order.
Collector's order. Annexure 4.
Issue interim order as prayed for till next date of hearing. Okay.
Item 20.
Well, I may be allowed to correct the.
Yes, I have permitted you.
Yes, I'll do this.
The counsel for the petitioner to correct the, amend the cost item. Okay. Next.
Item 20.
My lord, I am here challenging the order of the Tahsildar body dated 16/10/2025 by changing the marketplace.
Changing the marketplace.
My lord,
Changing the marketplace
my lord,
means what? Shifted.
shifted the marketplace to nearer to the college, where the more than 3,000 students are reading. And a medical is there. All the persons are affected by polluting fish market, chicken market are prevailing there. So that I want to change the place. And in this respect, I have filed a representation before the Tahsildar.
Who are you?
I am the petitioner.
No, petitioner, all right, I understand. What is your role in this?
That I am the inhabitants of that area.
Whether you are studying in that college?
I am not, some students are reading there.
Whether any of the students are your children?
My lord.
Whether your children are studying there?
My children are studying there.
Studying there? Where have you stated?
My lord.
Which of your children are studying there? Where have you stated?
The children of my villagers are reading there.
Not your children?
No, my children.
Then you go before the PIL court.
Yes.
My lord.
But apparently the cause espoused is of social action litigation. First up, push this case before the roster bench if necessary sets of papers are filed. Next.
Item 20.
20, well.
Was it 28?
May I please, your lordship? Lordship, here, my lord, petitioner challenged the transfer order for 3 grounds only, my lord. Ground number 1, my lord, she has been transferred to a distance place after the within the parameters that is in prescribed.
How many kilometers?
My lord, more than 25 kilometers. Problem is
25 kilometers.
My lord. But she is having a child who is a disabled person and reading in the school where previously she was posted. Therefore, only she is the caregiver mother of that child.
Child is suffering from what?
My lord, at page autism spectrum disorder, my lord. Up to more than 60%, my lord.
60%?
My lord.
Yes, brother.
My lords, yes, approach director. Yes, Annexure 6 is pending.
Pending, but till consideration happens, you don't transfer.
Provided is not relieved, my lord.
No, my lord. She has been deemed to have been relieved on the same day, on the same order.
Deeming they will do, which legislature can do. Whether officials can do the deeming. Deeming is an attribute of the sovereign.
Annexure 4, my lord.
Challenge is to the transfer order dated?
Dated, my lord, 25th 10th, 2025.
A copy whereof avails at annexure?
Annexure 4, my lord.
What? First. Counsel for the petitioner submits that the transfer is vulnerable from challenge on the ground that to a far off place his client has been transferred. Semicolon. His client has got, petitioner has got a child suffering from autism related disability to the extent of more than 60%.
My lord,
of 60%.
60%, my lord.
60%. Why disability certificate dated?
Dated, my lord, 13th December 2024 and validity of to December 2027.
Lastly, her application for retention at the same place has been kept pending.
At Annexure 6,
At Annexure 6. Council cites the apex court decision in Varadhara versus State of Karnataka in support of his contention. Next paragraph. Learned AGA Mr. Behera request accepting notice for the vote. He opposes the petition, citing the very same decision to the effect that the government employees are liable to be transferred in due course and that such transfers cannot be altered. First, having so contended, he agrees with the suggestion of this court to instruct his official branch to look into the grievance of the petitioner as has been heard in the subject representation in a time-bound manner. First, he caveats that all contentions of the parties be kept open. First, with this proposal, counsel for the petitioner agrees. First, in the above circumstances, petition is disposed of. The impugned transfer order shall not be given effect to till after a decision is taken on the representation of the petitioner and 1 week lapses after the same is communicated to her. First, all contentions are kept open. Next paragraph. Open to solicit information document, etc. Order.
And OP4 may be directed to allow her to continue there.
OP4 is directed to continue the petitioner in the same place wherein she was working before the issuance of the transfer order. First up, this direction has been issued because the OP number 4 has stated in the impugned order that the petitioner is deemed to have been relieved, the deeming being one of the attributes of sovereign power in the light of apex court decision in Kasturi law versus State of UP, which is that year. State of UP versus Kasturi law. Can anybody cite that decision? Citation. My professor used to teach these things. He was a great professor of administrative law. Sovereign power, non-sovereign power under Article 300 of Constitution. 60's judgment it is. Correct. There 65 Supreme Court. That's right.
Item 22.
My pleasure, sir. This is a matter related to grant of MSCP or Lordship's order. I am already corrected.
You are corrected that?
Yes, sir.
Share the copy with your friend. Yes, Mr. G.
Item 23.
Ma'am, petition is a lady primary school teacher on contractual basis. She has made an application as per the resolution to transfer her from Koraput district to Ganjam district in the year 2018 without considering, and now he is 45% permanent disability, eye disability, and he is the
Singular disability.
45% permanent.
Myopia patient.
Myopia, 45% permanent one. And she is the only daughter of her family. Nobody is looking after her parents, madam. All of a sudden, without considering her application for inter-district transfer, now notice has been issued by the authority to disengage her. I am challenging the notice, madam.
Why disengagement is on what ground?
On ground, since you are, since the petition is absent from the duty, madam.
Suppose if she is absent from duty, she is a teacher.
Teacher.
What the children should do? Absence of a teacher is a sin.
Yes,
because teacher will be, the students will be put to prejudice.
Man, I understand your lordship's query, but she has submitted regular leave application with, as per advice of the doctor, she will, since the Koraput area is a cold area, cold climates, and
Cold climate.
And the doctor has instructed her not to
Go outside.
not to go in cold area. And
Sorry, but school is in cold area. What should be done?
in accordance with the resolution,
An actual 14 year lordship.
I have challenged that motivation.
Show cause
notification.
Cause, if so cause.
Then my sole grievance before your lordship is that my application is pending with the.
You tell that in the show cause. My application is pending, and without considering that, you have issued show cause. Therefore, show cause is wrong. You show cause. Till you will give some time to you.
She also submitted her reply, my lord.
Reply.
Annexure
No
15.
decision is taken on that.
No decision.
Let them take the decision. Thereafter, cause of action becomes co-head. Suppose if they take decision in your favor, still you will maintain the writ petition. You make some observation, wait. Yeah, you are laying challenge to the show cause itself.
So cause as well as transfer me from Koraput to Ganjam district as per their resolution.
No, if you are liable to be discontinued, that question will not arise. Now you have to show cause to this, and you have sent the, you have shown the cause. You have to take the decision. Mr. G, till decision is taken.
My lord, what is happening here? He is on contractual service. He has not yet been regularized. Let him be regularized first, then inter-district transport.
I have enclosed collected under RTI Act. Some contractual teachers have also been inter-district transferred by the government.
Just anyway, then you have
cannot
the
be
show
taken
cause
by the authority.
Yes.
You have given the show cause notice.
Yes.
Your lordship,
He has shown the cause. A decision has to be taken on that.
Let them take it.
Till decision is taken, he don't precipitate the matter.
Well,
All right?
your lordship with some observation.
Some observation means you argued very well.
No, my lord.
What else?
No.
Or I gave the dictation very well.
Since my learned as senior has said that,
Wait.
Since I am contractual teacher, I cannot be transferred. But contractual teachers have been transferred, my lord. Inter-district.
The grievance of the petitioner has been scripted in the prayer column of the petition as under. First, kindly be seated. Counsel for the petitioner submits that his client has been suffering from 45% ocular disability and that he has been on contractual employment and that now he is sought to be removed. First off, he draws attention of the court to the show cause notice dated 19/8/2025, a copy whereof avails at Annexure 14, to which counsel submits that a reply has been already made. First off, he further content argues that in all likelihood, the petitioner would be discontinued from service. And if at all he is continued, he would be shifted to some other district. First off. So contending, so arguing, he seeks interference of this court for appropriate relief, for granting appropriate relief. Next, kindly be seated, Mr. G. Learned AGA Mr. G, on request accepting notice for the official notice, vehemently opposes the petition, contending that there is no coherent cause of action in as much as what has been issued to the petitioner is only a show cause notice. Petitioner himself says that he has submitted the reply and therefore he should await the decision making at the hands of appropriate authority. He also tells the court that ordinarily in show cause cases, writ court does not interfere. First, next one, having heard the learned counsel for the parties and having perused the petition's papers, this court is inclined to grant a limited indulgence as under for the following reasons. A, petitioner is in contractual employment and that he has been issued a show cause notice as to why his services should not be dispensed with. First, petitioner has already submitted his reply to the same. First, a decision is yet to be made by the jurisdictional authority, keeping in mind all relevant factors. First, thus, as on today, there is no decision taken, and therefore the cause of action is incoherent. First of all, learned AG Mr. G is right in telling the court that a petition is not maintainable on an incoherent cause of action. First, next paragraph. Learned counsel for the petitioner is to an extent right in telling the court that a citizen need not wait till a heavy injury is inflicted on him. First, a genuinely apprehended injury is also a legal injury in Greek jurisprudence. Says Justice B.L. Hansaria in his treatise, Great Jurisdiction, publication, etc. The Enlightened Institute, something like that. Asking a litigant of the kind to await a final decision is taken is like asking a sugar patient to wait till gangrene develops. That would not augur well to the realm of justice. First, be that as it may, justice of the case warrants a limited protection being given to the petitioner. And first, next, in the above circumstances, petition is disposed of with the direction that till a final decision is taken in the matter by the appropriate authority, no precipitatory steps should be taken against the petitioner. Petitioner shall be continued in the same place wherein he has been working till after the such a decision is taken. All contentions are kept open, no cause. The web copy to be acted upon.
Petitioner is a lady, your lordship declared he is same.
Okay. You are not using prefix in this great land. In this great land, I am reading 2 books on the history of your state. They use Srimati, Shriman, Shriyut, Shrijut, you say, but no problem. But nobody is using Srimati. How I should know the gender? They are indicative, they are gender indicative they are. Apart from respect, they are gender indicative also. Such prefixes, you should use them. Apex Court has said that. Calling a lady without saying Mrs., Miss, Srimati is offensive to womanhood. Yes. Item 24. Yes, sir.
Fact B the certificate. Fact B the certificate. Some prayer is the direct the opposite to furnish the complete details, records, verification report alleged obtained from Bundelkhand University, Jhansi, basing on which the petitioner's B.Ed certificate bearing roll number so and so has been declared not genuine. Departmental proceeding initiated. That should be issue notice so that I can come up with
issue emergent notice. Mr. G is requested to accept notice for all OPs.
For all OPs.
All OPs. Matter is in a narrow compass. Call this matter in the second week of December 24.
Yes, that's all.
Can I revert after a couple of seconds?
This is employee who joined as Shiksha Sahayak on 13th of December 2006, my lord. And while he was continuing, he was made regularized in 2012.
Benefits.
12. He was regularized. And he died, my lord.
What terminal benefits?
Terminal decision. Now they say in 2025, after his death, when we apply, they say everything has been withheld because some wrong document was given by your husband at the time of the initial appointment.
When he was appointed?
I was appointed in 2006, 13 December 2006.
2006?
My lord.
Wrong document. Which wrong document was it?
ST certificate, Siruka certificate was given instead of UR category. You took admission while you were studying. Instead of UR category, you submitted ST category.
But on that apex code, now Milinda is diluted. The case of Milinda, apex code, where they granted relief, the residuary relief, the apex code says, once fraud is committed, it vitiates everything in matter of caste.
Here, my lord, they have not initiated during...
You take notice. Yes. Issue emergent notice. G notice for. Okay.
Item 26.
Challenge the order. Do you have that Milinda judgment with you?
No, I have another judgment. I brought, my lord, where it says, my lord.
Which year?
That is, my lord, of the 2013, my lord.
13 is overruled. 2013 is overruled. Okay. Just look into right. 2021 SC 3-judge bench overrules 2013 judgment. Yeah. Next.
Item 26.
The open number 1 OSHB, my lord, constructed house for LIG persons, my lord. LIG category. Like 2000, she plotted the advertisement. Like 2003, I applied.
How can RFA judgment be challenged? RFA number.
Yes, my lord.
So and so.
That is
how housing
maintainable. Yes, no, Housing Board Act, my lord, the appeal is provided. Against challenging the eviction order, appeal is provided before the district judge, my lord. Yes, my lord. That was confirmed.
1 second.
My lord, housing.
Slow, go. Hello. No, you are challenging the order of the appeal order of the that appeal was under section 96.
No, my lord. That is CPC, my lord. It is under, yes, my lord.
This is a special act.
Special act, my lord.
Which is that act?
What is a State Housing Board Act, my lord?
Housing Board Act.
My lord. In that case,
no second appeal.
No appeal, no revision, nothing. No further appeal or revision.
No, my lord, in this case, I have been instructed by the Housing Board to appear. My lord, first thing that is this matter is not within the assignment of this one.
It's not in the
allotment, yes, allotment and yes,
that this matter challenging the order RFA is assigned to Honorable Justice BP Rautray.
That is under 96. No, my lord, it is under 96. That my lord is trading word that is under 96 of CPC.
That's under 96 CPC.
No, it is not 96 CPC.
It is a statute.
Yes, it is special statute. And allotment is your lordship's assignment. Allotment of the house by any authority.
No, my lord, order
for that
being challenged against the RFA.
No, you call it RFA, MFA, that's in other high courts. We call it.
1
second, sir. You are wasting time of the high court. Where appeals are provided, they are called regular first appeal if it is under 96, regular second appeal under section 100 of CPC. Where other statutes provide for appeal, like Land Acquisition Act, Workmen's Compensation Act, section 30, those appeals are not regular appeals at all. Therefore, he is right. You accept notice and you say something. Yes. Often they may not argue because what he says appears to be sensible. If they are regular appeals under CPC 96, 100, yes, then what you say is correct. If they are under special statutes, If both of you agree, I will send it to brother.
No, my lord.
It's another thing.
It is before lordship. It is assignment before lordship. That is not. That is not.
So Satpati may, brother Satpati may say, no, you cannot change my roster by your agreement.
The assignment of the Honorable Justice BP Rautai, that is a writ petition civil arising out of a writ of a first appeal under Article 227 Constitution of India in the year 25 onwards. Assuming that I am submitting.
You just look into it. Issue emergent notice. G is requested to accept notice for one. Sir, you appear for which?
Opinor one.
I am for the
appear for whom?
Of the housing board, Miller.
Where is the housing board a party here?
Yes, Opinor one, madam. Opinor one.
OP number 1 is competent authority.
Of the housing board.
Then G is not appear. G is not appear.
No.
Similar panel council Shri signs appears for OP number, accepts notice for OP number 1. Emergent notice to the west. 2 to 8.
In the meantime, they have issued annexure 14 million to vacate the house.
Till next date of hearing, don't
Yes.
No, Miller.
you are not entered caveat.
Yes.
You can only appear only if I permit you, not otherwise. Application is moved in I number so and so supported by an affidavit. First off, counsel submits that there is arguable case and it merits a deeper consideration. First, he also tells that unless the impugned order is stayed, his client runs a risk of eviction. First, there is a...
Earlier, my question is,
there is some...
earlier, on same issue, petition was filed, that was also overturned.
The counsel for the OP number 1 is not heard in the matter. Since OP number 1 have not entered caveat. Okay, put that. In the above circumstances, the petitioner shall not be evicted till next date of hearing. Next date of hearing.
Copy.
Give copy.
Yes, madam. I will serve the copy.
No, the date may be fixed for that because
The service, let service be post immediately after service of notice.
No, Miller, because they...
I am agreeable with your proposal. But date I cannot fix because it is not good on the part of the judge who hears the preliminary hearing.
My submission that should be because since I am appearing,
you are OP number 1
OSHB that this is a allotment in 2003. So after for a long time, he has not taking possession because of this such type of litigation. Thrice writ petitions has been filed, and that has also been dismissed by the Supreme Court. So several litigations.
You to show bona fide, you deposit certain money in the court. Otherwise, I will recall that order.
And not a single letter has been issued in favor of the.
Yes.
How much? How much you will?
I will take instruction.
No question of instruction. Then no, recall that order.
Any amendment also may
deposit 50,000 rupees in my court. This order will inure to the benefit of petitioner if he deposits a sum of rupees 50,000 with the housing board.
No, Miller,
with the registry.
Miller,
till next date of hearing.
No, Miller, that house is that has been leased out. Lease deed has been executed in favor of the opposite party.
What is the renter?
That's not true. No locus standi at all.
But you have no locus standi to oppose because you have not entered caveat at all.
Miller, that is separate thing.
Oh, we separate. That's the law. What is the rent you are paying there?
No, rent it is not it is allotment, not rent, Miller.
Allotment.
It is sale process, Miller. It is 99-year lease, Miller.
99-year lease.
Yeah, permanent.
It is in favor of
your lordship, and 50,000 within a week, Miller.
Then 1 lakh rupees within 1 week.
50,000, lordship,
Next, if deposit is not made, the impugned order can be executed.
Within a week, before OSHB.
Before registry of this.
Before registry.
Date may be fixed. So that
very difficult way. I will say post immediately after service.
Victimized.
All right. Call this matter in the second week of December.
I will take notice to other 2 to 8 minutes.
Yes.
By restore post.
Item 27.
That CBSE matter. In similar matter, your lordship has issued notice. Here, my lord, only prayer is that I will serve notice on Mr. T.N. Patnaik, so far as the opposite party number 1 to 3 are concerned, and I will take notice by speed post in respect of OP number 4.
Emergent notice, first off. Say, the panel counsel, Sri Patnaik, is requested to accept notice for
1 to 3.
1, 2, and 3. First off. Emergent notice to forward. Yeah.
Similar matter has been posted to 2nd week of December.
Call this matter along with WP number.
That I have already.
Yes.
Item 28.
Please, Lordship.
Yes.
The PCL, that is Bharat Petroleum Company Limited, invited application for dealership, petroleum dealership, my lord. That application, the condition was that the applicant has to own land, commercial viable land. The present petitioner commercial viable land. So petitioner had the commercial viable land, so applied and got the license also. The license was given for 15 years. On completion of 15 years at the time of renewal, we entered into a partnership with opposite party number OP3, opposite party number 3. And license was given in the name of the opposite party, partnership form. The land belongs to me. Now, what happened, my lord, during the meantime, my lord, there was a dispute between the partners. So we wrote to the BP, because there is a condition in that if there is a change of status, then we will have to take permission from the company. So we wrote to the company for seeking that we want to dissolve the partnership. So kindly, instead of doing that, they said that we resolve the issue. 2-3 letters are issued. Thereafter, my lord, they wrote a letter to offering a holiday scheme. I do not know what is that holiday scheme, but holiday scheme, they have stated some features.
But I want holiday. We are very happy to enjoy holiday.
So, holiday scheme. So, I said that if holiday scheme, if I ultimately, then holiday scheme will have to give it to me because I am the owner of the land. Lordship, kindly see, but that now they have said that holiday scheme they have diluted.
Come to para 6.
Para 6.
Of page 66.
Page 66, Lordship.
What they say appears to be the correct position of law in Partnership Act.
Yes, partnership, my lord. What I am
kindly read para 6. That's
yes, sir. So I am sorry, para 6. Para 6.
Partnership cannot be restored to proprietorship.
Yes, my lord, that is
unilaterally without consent of us.
Yes, my lord, that is what I said. I can seek dissolution of the partnership if after they permit me, after they give the consent. Because Lordship kindly say the page 48, my lord, page 48. That is the reason why he asked for the permission, my lord. So page 48, my lord. That condition.
48.
Page 48. Clause 10.
Not to change
the constitution of the license for dissolved partnership, nor admit a new member of the allowed member without obtaining previous consent in writing of the company. So we wrote to the EA and
so with the permission they can be done.
Permission.
So that you had sought for.
That you had sought for.
Where is that letter?
Well, letter copy unfortunately I didn't, but they have referred to my application. Let's see page 56.
56.
Page 56. Page 56 and another letter also, 18 to 25. But the Lordship second para. For the letter received by the territory office was both DPSL signature Amit Kumar Lat and Srimati Rita. The letter submitted by you individually, both of you have expressed that there is a dispute among you, but the result in loss of sales from the retail outlet. Further, in the letter submitted by Srimati Gitalani Garthia, says requested for cancellation of partnership. And same letter, then thereafter is referred to the holiday scheme as follows. What are the features of the holiday scheme? And then, my lord, another letter they have also issued on 11/8/2025, saying the same thing. Now, here they have stated that they have gone for this. They said that agreeable, but directed to directors to hand over the year. In dissolution partnership, it has got specific, as per Partnership Act, the specific procedure is followed.
Section 43.
43.
Issue
Platform.
emergent notice. Go to cost item. When I issue notice, you should take me to the cost item.
Yes, my lord.
No,
My lord, private property.
1 and 2.
1, 2, and because 1,
issue emergent notice.
1, 2, 3.
Returnable within 3 weeks. Interim order as break for till next date of hearing. About that, heard the senior petitioner, much of the council on record for the petitioner.
Much obliged.
Issue emergent notice. Modern science is okay.
Item 29.
Please, Milords, may I be permitted to place on behalf of Mr. Saab, please? The petitioners here, Milords,
Are directing OP number 2 to publish the final merit list of main written exam.
Please, Milords.
If that is done, you will be happy.
Please, Milords, I must say, Milords, there is only one issue here. Milords, we find our names in a provisional shortlist, provisional list. Milords.
Yeah.
Thereafter, Milords, we were called for document verification. Now, Milords, the only thing that separates us from an appointment letter is if a final merit list is published. Now, Milords, there is
the examination took place.
Milords, the 22/10/2024. 2024 was when, Milords, the advertisement was.
I'm asking a question.
Please, Milords.
You should answer the court's question.
Please, Milords.
When examination was held?
Please, Milords. The examination, Milords, I guess.
1907, it was July 25. Main written examination of Sanskrit teacher. The retraining is made available in that individual kinds.
Plus, the examination was held on 15/5/2025 and 17/5/2025 Milords. Milords will find it at Annexure 6, page.
Right.
Milords, thereafter, Milords.
But take notice. Well, I'm convinced.
Please,
not to
Milords.
still argue.
No, Milords. I just want to be one thing, Milords. There is one other petition, Milords. A candidate has approached this honorable court where notices have been issued, Milords. In that case, Milords, there was an interim direction stating that the selection procedure can continue, but no final decision will be taken without leave of the court. So therefore, Milords, the only thing that the commission will not do, Milords, as per the order, is that they will not issue me an appointment letter. But otherwise, Milords, they have not come up with a final merit list. Because, Milords, I'm aware that this court is in session of the matter, Milords. In fact, that matter is coming
this
up.
matter along with that.
Please, Milords. It is coming up tomorrow, Milords.
Tomorrow?
Please, Milords. The writ number is writ petition 16242 of 2025. Milords.
Then instead of issuing notice now, I'll have this matter tomorrow. Let it come tomorrow because they will not have a short notice. They will have no.
Please, Milords, I can serve on the panel council, Milords.
Issue notice. Please. Learned AG is requested to accept notice for 1. Panel council is requested to accept. Panel council Shri
Sanjeev Swine. Shri Sanjeev Swine.
So requested to accept notice for
2 and 3.
2 and 3. Director of Secondary Education, Mr. Behera will avail. 1 and 4, Behera. So call this matter tomorrow. Along with WP number. Call this matter along with WP number.
16242 of 2025. 16242 of 2025. Awesome. I'm so grateful.
But I said short of accomplishing the recruitment process. Please, that means drawing the final list is not conclusion of the recruitment process. Selection process is complete.
Selection process is complete, Milords, and Milords, in the other subjects, Milords, the appointment letters are going to be given on this Saturday, Milords. That is Milords, the anxiety. That is the anxiety. I'm so glad.
Item 30.
Item 30. Similar order has been passed. Yeah.
Yes,
Similar. My lords, here, he was transferred to a school where only one teacher is there.
No. My lord, my grounds are threefold. My first ground is that at the instance of the MLA.
My lords,
yes. And second is that in the transfer order it has been mentioned that as if the transfer order has been made on my own representation. It's not. On my own representation. And the third is, Your Lordship may kindly see, the order passed by the district education officer,
serial number
it is without jurisdiction, because Your Lordship may kindly see the scheme.
Who is the competent authority?
But the competent authority is the director. Your Lordship may kindly come to page 24 of the notification.
24
of the notification. Para 6. An authority
are they transfer guidelines?
Yes, transfer guidelines. Page 24. An authority competent to transfer a teacher can transfer the teachers within 16th April to 15 June or the last date fixed in the calendar contained herein or notified by government, a year whichever is later. During the rest period of the year, the teacher can be transferred only by the order of the next higher authority. Here, my lord, the district
becomes an order without non-effective. Yes.
My lords,
therefore, your lordship pass that order.
My lords, kindly see page 14.
1-4.
My lords, the notifications that the committee is competent to make transfer of inter-district.
With the committee comprising of MLA?
No, my lord.
Not that.
The collector.
MLA is also there.
Is there?
Yes.
In the committee?
Yes.
Where is that?
The collector is there. District level transfer committee, my lords. And
it comprises of?
It comprises of, your lordship may kindly see, the district level transfer committee at page 23. The collector and DM of the district chairman, district project coordinator, RT, SSA member, all block educations of the district member, district education officer, member convener.
But not MLA?
Not MLA. So far as inter-district transfer is concerned, MLA is one of the members.
For this intra-district, no?
Yes. My lord, my submission is, my lord.
Who has made this order?
My lord, the district education officer who is not competent. That is my first ground. Second ground is, the second ground is on the ground of rationalization. My lord, may kindly see, here, my lord, there are 95 students. Your lordship may kindly see the transfer guidelines itself.
Where is it said that it is made on your request?
My lord, your lordship may kindly see, that is Annexure 1. Annexure 1.
No TAD will be allowed.
No TA and DA will be allowed for the purpose. Then, my lord, they say
this.
Yes.
They said TAD is not allowed.
Yes.
Where is that? On your request.
Well, no TA and DA will be allowed for the purpose.
That will be wrong then.
Well,
but because
that means
transfer. No, you are inferring it.
Yes. That is my inference. And my lord, your lordship may kindly see Annexure 1. They say that on the basis of rationalization. My lord may kindly come to the transfer guidelines itself. Here, I have categorically stated there are 95 students in the school, and that ratio has also been mentioned in the guidelines. My lord may kindly come to page 20. Page 20.
Page 20.
20 of the guidelines. Annexure 2. That government notification. Primary school. This is a primary school. 91 to 120. 91 to 120. 4 teachers, including headmaster. There are already, including myself, there are 4 teachers, including headmaster. So the transfer cannot be made. The transfer has not been made on the principle of rationalization. And without jurisdiction, because it has been.
Yes, Mr. Bain.
My lords. My lords, my submission is that, my lords, page 13, serial number 7, he was transferred to a school where there is only one teacher. Minimum 2 teachers are required as per the norms. That is why he was transferred. And his.
How many?
My lords?
91 to 120 it is.
My lords,
You have seen that column, na?
that is requirement. That requirement doesn't entitle him to stay there, my lords. What I humbly say. And my lords, Annexer 4, his representation is to accommodate him in nearby place.
That is my alternative prayer. That is not my this whole prayer.
The representation, what is your
Well, representation I have stated that to cancel the transfer order or to give me posting in any nearby school. That is my alternative prayer.
Your primary school and or in the alternative to transfer me to any other.
Because I am suffering from some.
Let them transfer you to any other nearby school.
Nearby school.
Nearby school. Which school you want?
Nearby school, my lord, I cannot indicate the names. I cannot ascertain the names.
Matter tomorrow.
Well,
you indicate nearby school, that so that they will send you to that place.
Well, your lordship may kindly see annexure.
My lords, where it is necessary, because my lords, what students are not getting.
The station senior teacher.
My lords, only one teacher is there. So it is necessary.
I am not the station senior teacher.
The question is, who can transfer?
My lords, this committee is competent. No. My lord.
Committee is competent to transfer. During what period? During the particular period committee is entitled to. The other transfer during the non-season period, the higher authority, that's what the text of the guideline reads.
Yes.
Whether these guidelines have got statutory power. These are only guiding lines.
My lord,
this is a guidance
under the Right to Education
RT Act. Under the RT Act that has been framed.
It is
so it has got statutory
force.
Yes, yes.
That is not mandatory, your lordship. It is a transfer.
You are saying that it is not mandatory.
Everybody will stay in his convenient.
No, if competent authority passes out, or during the season, if you pass out, because transfer, though Affix Code said in that Varadha Rao versus State of Karnataka, transfer is not a condition. This is true.
That is an incident.
Problems.
The lordship may
representation.
Representation may
you
be
consider representation till consideration happens. Don't disturb.
Yes.
You can't say you go and report it. Then we'll consider the representation.
My lords, there is.
Is he relieved?
No, I have not
yet been relieved.
My lords, there is exigencies. Otherwise, I have not.
But your lordship may kindly say annexure 3 my medical certificate.
Question is, it's one interest. What he is saying is,
yes,
the interest of the children, community of the taught, is paramount.
But some other teachers are there. Well, which having longer stay. And so far as my school is concerned, I am not the station senior teacher. Their guidelines says that the station senior teacher, if at all any transfer is made, the station senior teacher should be
first come, last go.
Yes. And your lordship may kindly see annexure 3. I am suffering from some ailment. And the doctor has advised me.
Your doctor will advise everything, I tell you. They can't go, but they will advise that you take salary and sleep here in your house and part of your salary with me.
Yes.
That is no problem. Everybody will have some or the other problem. The very body system is like that.
Your lordship direct the collector to take a decision.
Let them, you consider the representation. You take the decision within 1 day. You take decision within 1 day and shift him to the nearby.
Provided
available. Petitioner, kindly be seated.
Yes.
Petitioner is knocking at the doors of Writ Court seeking invalidation of the impugned order of transfer dated so and so. Kindly look into that. Learned counsel appearing for the petitioner advances the following grounds seeking invalidation. A, the transfer is by the incompetent authority. Number 2, the transfer has been made not for the purpose which has been spelled out in the transfer order. C, the transfer is inferentially made on request, whereas no request is made. D, the representation of the petitioner has not been considered and petitioner is sought to be relieved of on a war foot, which is bad. Next one. Learned AGA per contra appearing for the office per contra contents in support of the transfer order. He cites the apex court decision in Varadharao versus State of Karnataka to the effect that all public officials are liable to be transferred and there is no complete immunity from such transfer. Semicolon. While effecting the transfer, a host of factors enter the fray, and it is the executive which will take the appropriate decision, and therefore, writ court is not expected to interfere. Semicolon. Lastly, he adds that the transfer is made for the best interest of the community of the tort, and therefore that interest should override the interest of individual employee. First. Next, having heard the learned counsel for the party, then having perused the petition papers, this court need not undertake a deeper examination of the matter on the line of contentions put forth, in as much as petitioner's representation dated 25/10/2025 is still pending on the table of OP number 3. First, the apex court in Varadharao Supra said, where a grievance is raised by the transferred employee, the competent authority has to grant redressal, keeping in view the policy guidelines. First, this apart, all contentions put forth across the bar can be looked into by the competent authority, since the gist of the same has been stated by this court in this order. First, that being said, the justice of case warrants keeping the impugned transfer order under suspended animation till a decision, a meritorious decision is taken on the subject representation by the competent authority. First, ordered accordingly, a writ petition is disposed.
Lordship may say that
to continue in the same place till a decision is taken on his representation. All contentions kept over.
Item 31.
My Lord, the order dated 1st August 2025 by your Lordship first is not complied yet, my Lord. Your Lordship, for a moment, I am just placing you the order of this Honorable Court in writ petition number 15516 of 2025. Hard learned counsel appearing for the parties. Page 9.
Go to the operative portion. You did not read whole judgment. It will take 1 hour.
Your Lordship, just despite service of notice, no objections are filed from the side of the opposite parties. However, this 4 and 5, one paragraph. Despite service of notice, no objections are filed from the side of the opposite parties. However, this court in matters like this cannot eternally wait for filing of objections, asking for the litigants to wait in queue with no justification whatsoever. Whenever the cause is brought before this court, earliest redressal has to be granted to the litigant, whether the authorities and the government would file objections or not. In the above circumstances, this writ petition is allowed. A writ of mandamus is issued to opposite parties to consider the subject representation dated 4/11/24, a copy whereof avails at Annexure 1 within a period of 4 weeks and in accordance with law. Report of compliance should be filed with the Registrar General of this court within 1 week. Next following, failing which it is open to the petitioner to make appropriate application.
He should permit me, then we can proceed.
To this court to take punitive action. Your Lordship, punitive action against.
My lords, actually, my lords, the contemners are not the jurisdictional authorities, my lords. This is for construction of village road. The BDO has sanctioned the money and he is the authority. He has not made party either in the writ petition nor here, my lords. What I can take instruction, my lords, but the direction should be the competent authority, that is video. He has not been made a party. And secretary was how he will.
My lord, the collector and executive
not
engineer
the
also-
jurisdictional authority, my lord.
collector and the executive engineer have been also represented after the order has been passed. The petitioner has represented with a copy of the order.
First time it has come.
My lord.
Yes.
You take notice and then say something on that.
That will solve the problem, my lord.
That will solve the problem.
If video will be a party, then we can look into the
In the
matter.
read petition, video has not. Read petition, there is another lawyer, my lord.
No,
So-
that lawyer, who is lawyer is irrelevant. Cause before the court is relevant to me. Principal Secretary, Works Department is there.
Collector is there, my lord. Executive engineer is there.
Please, don't spoil your case.
My lord.
See, Principal Secretary Works
He is a party, my lord,
PWD is
but
there.
he is not jurisdictional authority, my lord.
Who are the jurisdictional authority?
The block development officer is the jurisdictional.
No, he should have said to this court.
My lord, I understand that, my lord.
And that he did not take up that stand.
My lord.
He has not filed objections also.
My lords, in writ petition, that was not pointed out to my lords also.
Had you filed the objections, that question would arise.
My lord.
How can I go behind my own order?
My lords, I'll talk to the collector, OP number 3.
Otherwise, I have to implement the order.
My lord.
Order right or wrong, it's an order.
My lord. So let me call after 2-3 weeks.
Then in the meanwhile, you have to do the things.
My lord.
Issue emergent notice. Mr. Behra accepts notice for OP number 1. Emergent notice to the rest. Let notice go, emergent notice go to the other people by police notice. For what you will appear?
I will take instruction.
Oh, they are private parties.
No private
parties.
All are official.
No private parties.
All private.
No private parties.
Kindly read the cost items. Read your cost items.
My lords, by name he has made party.
Private party. By name it comes. So
Yes.
court said it, they are private parties.
Yes.
Contempt petition I have.
Issue emergent notice. Emergent police notice to 2, 3, and 4. Let police go before them. Yes.
My Lordship, these are the page of writ petition. And Lordship, the first case is Lordship taken of that is WPC 40109 of 13. These cases where the points involved that the petitioners of the organization, they were engaged for running of the NCLP project, the National Child Labor Project. Now the project has been closed. Now the dues are pending with the government. They are not getting the dues.
What is your prayer in the petition? All these petitions say?
Yes, same, my lord, same.
What is the prayer? Let us see the text of your prayer.
That is first petition number 22033. That is my prayer is that, my lord, to disperse the dues amount. That is
9,12,818.
Yes, my lord. And my lord, so far as WPC number 40109 2023, in that case, the union government has filed the counter, shouldering the responsibility that the state government is to disperse the money. Now the state government has to give the report to the central government. Central government will
pay.
Central government already paid. Now the ball is on the responsibility on the state government. State government is not dispersing the money. The guidelines they have annexed.
There should be full stop, comma in your statements. I have to process them.
My lord.
So where are your guidelines?
My lord, that is counter filed by the union government in WPC number 40109 of 2023. Lordship, kindly take up that writ petition.
40109.
My lord.
They have adopted it in rest of the matters.
Yes. That is the first case.
Who appears for the OPs? You appear for OPs?
I am for OP number 1 and 3, madam.
Union of India.
Yes, ma'am.
What is your stand?
Our stand is that, madam, the claim made by the petitioner is time barred.
It's time barred.
Yes, madam. As because
the petitioner has himself admitted in his writ petition that I have submitted the bill in the year 2014.
When the work was done?
At para 4, my lord.
When the work was done?
My lord?
When the work was done?
My lord, 2014.
2015.
For the financial year 10 to 12. 2013 to 14, April 2014. February 2013 to April 2014. Paragraph 4, my lord, of the writ petition.
National Child Labor
Project.
Yes,
NCLP project.
Is it a statutory project or?
Yes, my lord, the government of India has implemented a project.
I am asking you,
my lord,
whether this project is relatable to any particular statute or
no, my lord.
Sentence is not complete. You have to have patience, or it is drawn in exercise of executive power of the state.
Executive power.
No statute, executive power. Because approach of the court has to depend. It varies. If it is statutory, one aspect. If it is non-statutory, other aspect. In the light of Ram Javaya.
It is running under a scheme, my lord. There is a guideline.
Now, have you understood the question?
Yes.
Perhaps you have not.
Yes.
Otherwise, you would not have made the statement. I am asking you whether this scheme is drawn under any statute or under executive power of the state. If under statute, the parameters of examination at the hands of the writ court, it will differ. If they are executive power productions, then Ram Javaya. It begins with Ram Javaya, goes to Parikar, etc. In the light of that, I am asking you, I am elevating the level of the case. I think you have to grasp that now.
My lord.
Who under the scheme in question,
my lord,
just note down. Both the sides agree and answer that the scheme in question is not statutory as such, since it has been promulgated in exercise of executive power of the union. Number one. Where is the scheme now? Just take me how the scheme operates.
My lord, lordship kind of belongs to annexure B by 3 of the counters in WPC number 4010/2023. That is starts with is number 18, my lord.
NCLP guidelines.
Yes, my lord. And my lord, lordship kindly glance to page 24 of that counter. Role of central government. Lordship, right to that, page 23.
Say para number, because there are 2 page numbers in my case.
Para number 3.9. The
3.9.
The institutional mechanism, my lord.
That is where map where the
diagram is there.
Diagram is there, na?
My lord.
The architecture of mechanism is as under.
Then my lord, lordship
labor.
Then lordship kindly belongs to para 3.10. That is fonts.
3.9 you asked me to read. I am reading.
My lord, that is the architectural design. How the project is to be carried out.
State labor department or other designated department. State level monitoring committee.
Yes, my lord.
The district project society. You are a society.
No, I have been selected by the project coordinator, district project coordinator, to run the NCLP school.
Monitoring committees, special training centers.
My lord.
Now, in this diagram, where do you fit?
My lord,
you do not fit at all.
I am selected.
I am answering. You are not answering my question. You are avoiding the question. Where do you fit into that diagram?
I am not within the figure.
You are not.
Yes.
Counsel for the petitioner, on being questioned, fairly submits that he does not fit into the figure, the diagram drawn in para 3.9 of the scheme in question. Yes.
My lord, then lordship 3.10.
3.10.
Which is the
under the NCLP scheme, funds are released directly to the project societies in the 2 installments. based on submission of specified periodic document reflecting progress of project activities, and the district project society in turn releases fund to implementing agency operating special training.
I stand corrected, my lord. I'm category socially center.
You fall into.
I'm coming under special training center.
But
that agreement, my lord, I have annexed, my lord.
You are a special training center.
Yes, my lord. The school.
Then first
I stand corrected.
Is wrong. Take out that. Remove that first answer. Yes.
Then, my lord.
Slowly, you should understand court's question. Otherwise, these mistakes happen.
My lord. Thereafter, the role of central government in that scheme. Flow of funds under the NCLP scheme. Figure 2. The Ministry of Labour Employment to District Project Society.
It is the scheme is implemented through the government, state agency.
Yes, my lord. Through the collector. Collector is the head. And now a project director is there. Collector is the head.
Come to 3.14.
My lord. My lord. The state government has the responsibility in the matter of planning, coordination, and monitoring of the NCLPs. The state level monitoring committee, headed by the Chief Secretary of the state, is meant for effective and efficient implementation of the NCLP scheme and convergence of various development initiatives. The state government of labor or any other department may be designated to monitor and review the functioning of child labor projects in the state and gives secretariat help to SLMC.
It is state level monitoring committee.
My lord.
May I clarify, my lord? May I clarify?
Yes.
Yeah, what do you know? Sorry, my lord, I'm virtual. This is a scheme introduced by the government of India, and the same will be implemented to the state agency. State government will implement it by way of a system mechanism. That system mechanism will be acted upon basing on the NCLP project. That project will implement through the state agency by a particular basing on the scheme constituted by the government of India. That is a fundamental issue. My lord is very pertinent question. It is, I appreciate my lord. Further, it is a act basing on the act the scheme will be introduced, or the state central government has introduced a scheme on its own for completing the same. It's according my lord.
But not simple. Go to the. He did not correctly answer because he has not read the scheme. You have stated the scheme is done to give effect to the statute. Go to, there is one paragraph I read.
Yes.
Go to the first part of the, where it begins.
Introduction.
There is one sentence. This is drawn to give effect to the statute itself, which
1987.
Where it begins. Scheme begins at?
Scheme begins, my lord, at page 18.
Page 18. Go to 18. All you come here and turn pages. This is like, in Sanskrit, it is called a Yuddha Kale Shastrabhyase. During war period, you are doing drill. Read entire thing, then I will be able to answer. You are not fixing the parameters of Red Court's examination at all. Simply arguing and going like Cattle Trespass Act. Which is that sentence where they have stated one sentence, I read it, in fact.
Recognizing that.
Come to page number 35. Item number 1. 1.2.1, Roman 1. Strict and effective enforcement of legal provisions relating to child labor under various laws. There are 13 legislations relating to child labor. So this scheme is essentially drawn to give effect to the provisions of those legislations. Those legislations you have to give now, because they have got different shades.
My lord.
There is a judgment of Justice Bhagavati of Supreme Court. If you read and come, you can argue this matter. Otherwise, you argue, I will consider this photo. That will not help you. And your first contention is it is time barred. Where is the limitation for that? Whether there is a privity of contract between you and the union?
Yes.
Where is?
No, myself along with the district coordinator, my lord.
No, how you are concerned with the union? Union, you don't have privity of contract with them.
Because my lord, the union government has floated the scheme.
Correct.
And implementing the district administration on behalf of the state is entering with the agreement.
In your agreement, where
Yes.
the union figures?
My lord, the annexure 1.
Annexure 1.
Yes. Annexure 1, that is my selection letter.
No, you said an agreement, formal agreement has been drawn, no?
Yes.
Where is that?
Agreement I have not annexed, my lord, but the appointment at page 9.
What I should do with the appointment order? Who?
Yes.
This is project director.
My lord, where I have been directed to execute an agreement.
Did you execute the agreement?
Yes.
Where is that?
That agreement I don't have, my lord.
Then how judge should do? Judge cannot come to your house to see the agreement.
But my lord, taking note of my grievance that the collector Cuttack has forwarded my grievance to the ministry, my lord, that it is not in dispute that I have not worked. Annexure 4 series.
You have completed the work.
Yes, my lord.
Accomplished the work.
Yes. Annexure 4 series, my lord, page 15. The collector Cuttack has written to the central government for disbursement.
What saying what?
That, my lord, that is page 15.
Release in grant in aid in favor of national child labor.
Yes, my lord.
On that. Cuttack office letter signed for the rest of the hours. Numbers of NGOs were collected from special schools. Your Utkal Sevak Samaj? No. But page 15 mentions that one.
My lord, that is.
No, where is the vinculum juris between you and the center?
Because, my lord, the center is protected the
Center
scheme.
gives that money to the state.
Yes.
So you have to receive it from the state.
Yes, my lord.
Your agreement is with the state.
Yes.
Not with the center.
No.
Then how can you maintain the petition against the center?
Because, my lord, because the entire scheme is protected by the central government. Because we are in dark that who will give the money and who will sanction the money. That's after filing the counter, we came to light that it is the central government. Central government already shouldered the responsibility to the state government. State government is now, my lord, I have obtained information that money is lied to the state government. Yes.
So you can't complain against the center.
No.
You admit that.
Yes, that my lord.
No, first understand. Otherwise, on record, everything is online now.
My lord.
You say that you have no grievance against the
No, my lord. That I cannot say because both the district administration is to submit report to the union government to sanction. Thereafter, the union government to release the fund. Thereafter, I will receive the money.
But you said that union has already sent the fund.
So that have not disclosed in their counter. They have already shouldering the responsibility to the state government.
No, you only say just 20 seconds ago that the center has already remitted the money to the state.
In some cases they have already. Some cases it is lying with the collector. My lord, this is the RT information I have.
Your money is lying with whom?
Your money, my money is lying with my collector.
Collector.
My lord.
So you have no grievance against the center because they have already remitted.
Particularly this case.
That's what.
Yes. Particularly for this case, WPC 40109, my money is lying with the
collector. We'll come to the collector. Who represents the collector?
My lord, I have to point out. In my counter at page 87, my lord, kindly have a glance to para 3. The ministry in turn his claim, ministry has issued a letter to the collector
saying,
para 3, my lord, accordingly the ministry was neither aware about engagement of the petitioner Suprativa by DPS Kotak, nor has any role in release of funds to them. As already mentioned in the preceding paragraph, the ministry does not release the fund to NGO directly. Therefore, this ministry cannot verify the veracity of the claims made by the NGO.
Anyway,
While
you
examining-
to the state. So you have no much concern here.
And the
money is to be paid. You have remitted according to them. The money is with Mr. Behra.
No, my lords, here.
Where is your counter?
We have not filed counter.
Then allow the petition.
My lords, what I submit. Here it is admitted that in this page 87, central government has not released any funds to state.
No, you have said in the reply in RTI. RTE.
My lords, kindly see this. Page 87. That is not part of the record.
Yeah, at least you should get copy of them. Then you will be able to answer.
Yes. Serial number 26, Suprativa.
Have you taken services? Now, if you say,
Madam, my lord, what I humbly submit, we have not filed counter. Here, the central government says, admits that we have not sent any money towards on this account, my lords. Petitioner's account. This page 87, the lordship, annexure C/3.
Now it is the collector. Party information.
Where is that?
My lords, accordingly, the ministry was neither aware about the page para 3, my lords.
Of a counter of the union.
My lord.
No, that counter, you have to say something because you are the intermediary actually.
My lord,
It is you who give the service.
Collector is acting under that scheme of the central government.
Correct. No, I am asking you
my lord.
very essential question, regardless of the thickness of the pleadings. Whether you have engaged the services of these people, utilized the services of these people or not, number one.
Right.
Is there dispute?
That is under the scheme of central government, my lord.
Well, we will come to that.
Entire money is to be borne by the central government.
I am not on that. First question is, did you enter into a contract with these people?
My lord.
You have entered. Number one.
And payment has also been made also.
To them we have made the payment.
No, my lord, the news is there. I have given the RTA.
Your claim is not admitted at all.
Claim is not admitted means what? He has worked.
Yes, exactly. That is to be verified. That is
the work.
My lord.
But how?
He has raised a claim of 3 lakhs rupees without any basis. And he was paid around exactly I am not, 1 lakh. And he has not raised any claim for 7 years.
Yes, brother, what is your contention, your answer to the, though limitation period may not be, the latches? Because the one judgment of...
When there is a money claim, that will come even...
That is I am pointing out.
3 years.
Claim is and
what's your answer? Ordinarily, though writ jurisdiction is not governed by Limitation Act, still the 5-judge bench of the Apex Court headed by Justice
Delay and latches.
Headed by Justice Hidayatullah. That bench says, though provisions of Limitation Act are not stricto sensu applicable to the writ jurisdiction cases, but wisdom will be drawn while adjudging delay and latches, taking into consideration the limitation periods prescribed for various causes of action. What is your explanation? Why did you sleep over the matter for so many years?
Yes, my lord. My contention is that...
Where have you taken up that contention? In the WP. It cannot be orally explained.
No.
You should lay the foundation in the pleadings. Then you can argue. Where is the foundational pleading?
There is no foundation pleadings regarding
the matter will go now.
My lord, my submission is that taking cognizance of my grievance, the collector who is the head of the project has taken cognizance. Now, when no action has been taken, I approach the log office of the one court.
After how many years you are approaching?
Yes, after, my lord, after 9 years, my lord.
Then 9 years is too long a period in man's life. See that R.D. Shetty versus International Airport Authority, for a delay of 3 days, Supreme Court denied relief. See that,
my lord.
So delay and that just depends. Even a short few days may be delayed.
But my substantial
For
right.
9 years, what is your answer? No.
My substantial right cannot be. So my substantial right will be increased, my lord.
What are your substantial rights?
I have been engaged. I have been utilized.
Correct. But you should have come to
But my lord, when scheme is there, the instrumentality of the state or union is to take action due to lapses on the part of the state instrumentality. I should not be suffered, my lord. When I do,
but law of limitation, latches. You admittedly 9 years after that.
Yes, that I cannot develop, my lord. Yes.
Then that's what. How to come to your aid now? See that Raman Dayarami last paragraph where they denied relief. Go to the last 2 lines, 3 lines of the judgment. They said no relief can be granted to a person because he has come after 3 days. They laid a whole lot of law and said no relief. We accordingly dismissed the appeal and confirmed the order of but see, the position would have been different if the appellant had filed the writ petition immediately after the acceptance of the tender of the fourth response. But the appellant allowed a period of 5 months to elapse during which the fourth respondent altered his position. Therefore, we do not grant relief to the petitioner. 4 months. And contract involving crores. They said 4 months. You are come here 9 months, 9 years. What is your explanation? Where are the foundational pleadings to that effect?
No, there is no.
Nothing. In any of the cases, nothing.
But any person recently they have some cases they have rejected. Some cases this one was directed to consider my representation. They have rejected.
No, that does not give you that way. That we keep open all contentions, including delay and latches while considering. Unless we say.
My lord, in that cases, the rejection on the ground that since it is a project has been closed in 2017, now the records are not traceable, they have rejected.
That's the reason, the very reason of why we prescribe in all civilized jurisdictions.
Lordship may call it any other day, I will develop it.
I have heard you now.
My lord, my dues is there, it is their admission. It is their admission.
Brother, you are not able to answer the basic question. Why 9 years? Where have you said anything about that? No. Unless you explain that, nothing can be done. By raising voice in the court, merits of the case are not altered. Even if your feeble voice, if case is meritorious, I will grant that relief. Raising decibels is one thing. Elevating merits of the case is another.
Lordship is I simply pray, my lord. Lordship direct to consider. Whether they will reject or they will allow, it is up to them. Lordship direct to consider, my lord, only.
What do you say? Consider keeping all of contentions.
My lord.
My lord, again it will make a new cause of action for raising the point before my lord.
But anyway, but you have not replied to him. Now you have filed the writ petition objections here. Why did you not reply to him when he sent the representation?
My lord, there must be many communication to them because they are sitting and coming after a wrong period, saying that this project has been done by us, you have to pay.
You should have sent the reply to the representations saying that belated claims are made, we do not entertain.
There is a new speaking order, yes. Speaking equipment, yes.
One sentence, that is the intent of 353 of the Constitution, 350 of the Constitution. Today morning I said 350 of the Article 350 is, although textually it is a bit different, that is how it has been construed by Madras High Court and by Karnataka High Court. When citizen gives a representation, raises a grievance, redressal has to be granted to him. You may reject it.
I could also pass such a
Lordship, for out of the list, There is WPC 40109.
First, you tell in which case give the chart now. I will call it at 2 o'clock. Come with the chart. How many days delay? How many? What is the delay period? Then, depending on that, I will consider. All right.
Almost same, my lord. Almost similar.
Similar. All 8-9 years only.
8-9 years almost.
You are very fair. How to deny relief to you? I don't know.
Almost.
Yes, sir.
Can I take your words?
Yes, sir. Yes.
Item 40, they have just served me a copy of the interim application. They want to vacate your lordship's order. So they have just served it. I require 2 weeks time to file the counter.
And your lordship may call it along with another case, identical case. That is WPC 24791/20.
Yeah. That day, we'll hear the main matter itself.
Yes, counter has been.
Because I have read these papers twice. Yes. Both the cases you had argued, I remember.
So I'll file also a rejoinder. Kindly grant me time, 2 weeks time for rejoinder and reply to objection.
Next item 33, my lord.
Agree with the proposal of this court that the main matter itself may be disposed of. First off, learned senior advocate appearing for the petitioners seeks an accommodation, short accommodation to file the rejoinder to the counter filed by the state government. First off, call this matter on kindly pull down a date from the calendar. Whichever date you want.
December
26.
On that day, no adjournment.
No, I don't seek adjournment.
No, I am telling it because both are sides.
Today he served the.
That's right. Yes. Therefore, I am giving you time now. Yes, call this matter.
Along with?
Along with WP number so and so.
4791/20.
Request for adjournment shall not be entertained.
There you are add.
Item 33, if I may.
Counter.
No, filing of reply to their
counter.
Application.
Their
they
application.
have filed another application.
No, impression is, the impression given to me and by me to you is, matter will be heard on main matter itself.
Yes.
Therefore, other things will pale into insignificance now.
Okay. Interim order to continue.
Interim order to continue till next date of hearing. Yes.
May item 33, my lords. Sorry for disturbing the lordship. My item 33, certain documents need to be placed before your lordship.
33?
Yes, my lords.
If I have read the papers, I will not give time. 33 years. This was urgent at your instance only.
My lords, I have not gotten, I have applied for the certified copies of those
documents you applied for.
My lords.
You want some time for
1 week's time, my lords.
2 weeks at the request of. All right.
I'm deeply.
Your Lordship, item 36, I'm for the opposite party. Your Lordship, 2 weeks may be granted for.
36.
But I am
item
24 matter.
I know, item 36.
Yes, sir.
36 is 2024 matter.
Yes, madam.
Yeah.
No response has been given, and in the meantime, constitutional work has been started. That's why I pray my situation is taking time. Only a short time will be given, madam.
Short time.
Can we grant 2 weeks?
Little bit.
1 week.
Because constitutional work has been started. Yes, 1 week.
1 week. Yes. Call next week at the request of. Yes.
In the meantime, the counter.
Yes. Counter in the meanwhile, counter may be fine.
Okay.
Yes.
I beg pardon, item number 37 may be taken up on Friday.
So, 15 of 4010?
4010 and 23. That is next stage. My lord. The claim has been raised since 2014 and it has been rejected.
When the work was done?
Work was completed in 2014.
Show that.
Yes, my averment.
You said 2009.
No, my lord. My writ petition averment is that.
No, government is one. Where is the government? Where is supporting material to show? that as on a particular date you have accomplished the job.
Yes, my lord, that is
What
12.
I suggest. Look at me.
My lord.
Hear my words. Disputed facts are involved.
Yes.
What I will do is, I will relegate you to the civil court, keeping open all contentions of the parties. I cannot decide because it's a contractual matter.
My lordship, my submission is that
I have not completed my version.
My lord.
If you permit, I'll complete.
My lord.
LIC of India versus Escorts Limited. 1986 Supreme Court. Page number so. O Chinnappa Reddy's judgment. Take out that. It says, in matters like this, writ petition is not maintainable, even if parties are state and the central government. Because disputed facts are in. You say, our work is completed in 2014. They say it is not true. Okay. Now, whether something is barred by limitation or not is a mixed question of law and fact. Therefore, instead of dismissing your petition, I will give you 8 weeks to file the suits. Within 8 weeks, 3 months. 3 months I will file the file. I'll give you.
Lordship simply direct the collector to, because my lord, why I am insisting lordship to look at, because there are 38 number of schools. In that letter, the collector admitted that one person, one organization like the present petitioner approached this honorable court. This honorable court directed to consider its representation. It was not considered. Then he approached the contempt by filing contempt application and found judgment released.
No, I cannot get direct consideration because they have drawn the battle lines, saying that you are not entitled to any.
Lordship, kindly glance that page. That's why I am saying, Lordship, kindly glance to page 15. A series of representation from communication from the state government to union government. Series of communication
saying
you release the fund. Lordship, page 15.
Page 1, 5.
Yes, 5, my lord. Lordship, I am reading. In inviting a reference on the subject above, it is to intimate that there are 38 number of NGOs were selected to run special school at various places in Cuttack district for the period from 1/8/2012 to 30/4/2014. As per the instruction of the Ministry of Labour and Employment, Government of India, the children studying in the above special school were mainstreamed in the nearby formal school. The grantinate in respect of 38 special schools in the district for the period from April 2013 to April 2014 is also pending for disbursement, out of which 3,46,650 is paid to Utkal Sevak Samaj as per the direction of the Government of India, Ministry of Labour and Employment, whose arose out of a CUTC number 31/22 filed by Mr. Utkal Sevak Samaj versus Sunil Partwal from the available unspent balance of District Project Society and CLP Cuttack. It is pertinent to mention here that the Ministry of Labour and Employment, within bracket Child Labour Division.
Behra, come to the last paragraph of that letter.
My lords,
is right in telling that you have recommended his case for release of the amount.
My lords, I will make 2-3 submissions. Para 4 of the writ petition. Even, my lords, assuming that it is totally correct, my lords, uncontroverted writ petition shows that it is barred by limitation. Uncontroverted, my lords. Para 4, my lords.
No, that para 4, all right. But he has produced this letter dated, 1 second.
My lords,
that letter date, where is that letter, brother?
13/7/2023.
Page number?
Page number 15.
15, my lord.
Come to that page number. What is the date of that order?
My lord. That is
23, July 23.
My lords. I am citing one judgment, my lord, of Supreme Court, my lord.
Saying,
by giving representation or any notice,
not extend
the
6th-year law student understands. But you have revived the cause of action.
My lord,
that judgment you have not brought because that was against you. Kindly come to this. See your It is not representation.
My lords,
You have kept the cause alive. It is not representative. Where is the rejection? Kindly read.
my lord.
Read.
My lords, this document recognizes his entitlement. My
Correct.
lords. That is not there. And from the writ petition, your lordship will not find any documents that we have admitted this is the liability.
No, which is this letter?
This is in general, my lords.
This is general. Who are those? Who are those agencies?
My lord.
The list I've given, my lord,
That is not part of the report.
yes.
Now, this letter, who are you, all these problems arise because you did not file your pleadings. This is the record. Is it from your record?
No, my lord. This is a writ petition.
Do you dispute this document?
Yes, my lord.
Disputed?
That is not disputed. That has to be taken into account from the ministry, my lord. Instruction to be taken. But, my lord, in my counter, one document, my lord, at page 14, wherein there is a cut-off date has been fixed by the ministry.
For
claim the liability, claiming of liability. Page 14, my lord. Kindly have a glance. Very, very important.
now what I am stating is,
when the one minute interruption. When the national NCLP scheme was merged with the Samagra Shiksha Abhijan, it was merged. Thereafter, one cut-off date has been fixed by the ministry, that is 31st March 2022. And
1 second.
Yes, ma'am.
Slowly, you should have, what is this narrating from Jim Chatting? 31/8
My lord.
date.
Date, my lord, 21st October 2022. At page 14, the cut-off date was 31st March 2022.
31st November.
2022.
2022. My lord,
1 second. You have to understand what you are only. This cutoff date is for whom?
For a letter was issued to the Chief Secretary of all the states and union territories to submit the balance liability, if any, within 31st March 2022.
But when he had
with supported documents.
When did he file that?
But the collector has sent the letter in 23, my lord.
Your cutoff date, that 23 means he said these are pending before you.
23, my lord.
See,
yes, ma'am.
Cutoff date for claiming is one thing.
Yes, ma'am.
Please appreciate this. You should have made the claim before a particular cutoff date. That I can understand. Question is whether he has made that claim before the cutoff date or not. Collector's letter is a reminder to you. It is not your case. He did not make the claim within the cutoff date.
He has represented in 2023, has same admitted in his writ petition.
Correct. Representation is leave it. He has said, I have already claimed.
In that letter, my lord, it doesn't clarify the petitioner was there in that. That is the ambiguity.
There is no problem. But on that ambiguity, you slept over. You should have asked the collector.
In order to release.
Why can't you bring somebody to control you? I am asking a question to you. You should understand. You are very slow in understanding, slow in responding. No processing takes place in the gray matter. Problem, how the judge should work with you. How can you expect that I should not lose the patience? How long I can tolerate all illogical arguments? I am asking you. You fixed 31/3/2022 as the cutoff date. Now, tell me whether he had put forth the claim before that date or not, on the basis of records. You should not try somehow to win the case. You are a government.
No, ma'am.
Government should be very fair.
Yes, ma'am. Yes. I bow down.
Yeah. I am asking you now, come to the letter of the collector. dated 21 October 2022.
Yes.
He sent that letter to you. What was your response to this? Leave the bad drafting of the petitioner. Nobody reads pleadings and other things nowadays. Anyway, I can understand. But how the litigant will mistake the court?
In reply to that, another letter was there at page 87.
Where is your reply to this letter? The collector said, understand here.
Yes,
please look at me. Look at me.
Yes,
collector sent a letters to you.
Yes.
You understood this letter. It is not your case that you have not received the letter because you have not controverted this hospital. Understood? If that is so, if you had any doubt about the factuals mentioned in the letter, you should have solicited a response. Where is that letter?
At page 87 of the counter.
Which prior to that?
87.
Yes, ma'am. 29 January 2024.
29?
29 January 2024. Ma'am. Wherein?
The first letter was dated? The letter of the collector is dated?
13/7/2023.
Your response to this letter is dated? The correct what it is?
That is that I managed to
29 January in connection with this
particular case only.
Particular case, madam.
29
January 2024.
What you have stated?
Yes, madam. I am placing that. This ministry is in receipt of a writ petition 40109 of 2023 Suprativa versus Union of India. The petitioner Suprativa was running special training center under the National Child Labour Project Society Cuttack. The subject matter of the petition relates to non-release of funds to the petitioner for the period February 2013 to April 2014 amounting 2,27,986. The National Child Labour Project scheme was implemented through a registered society under the chairmanship of administrative head of district concern. Under NCLP scheme, funds were released from the budget of the Ministry of Labour and Employment to the district project societies, who in turn allotted funds to the NGOs, local bodies, etc. at their end for implementation of the project running the special training centers, STCs. Accordingly, this ministry was neither aware about engagement of the petitioner, Suprativ, by the DPS, Cuttack, nor has any role in a release of fund to them. As already mentioned in the preceding para, the ministry doesn't release the funds to NGOs directly. Therefore, this ministry cannot verify the veracity of the claim made by the NGO. While examining the records, the following discrepancies have been observed in the functioning of DPS Cuttack. The NCLP guideline 2003 clearly prescribed that the project society should send the survey results through the respective state governments to the Ministry of Labour and Employment. The ministry then determines sanctions the number of special schools that can be operated in the district. However, the sanction of the ministry to operate NCLP schools during entire duration is not found on record. We may request the chairman.
1 second. What is meant by that? What is that he is saying? Reading means first you should understand and then tell me.
Yes, madam.
What is meant by that?
However, this sanction of the ministry to operate NCLP schools during the entire duration is not found on record.
That means go further. Yes. One more sentence.
We may request the chairman.
That job where have you done? Read further.
Yes. Request the chairman NCLP to furnish the sanction, if any, to this ministry.
Yes. Where have you done that?
But we have written to the collector, madam.
Only this, we have to take permission,
thereafter,
etc.
Thereafter, madam, that is the.
Where have you sent the proposal to the chairman?
That has to be obtained, madam. This is not in our record.
Therefore, the best way is
But that next paragraph is very important.
Your Lordship,
Madam, it is observed that surveys have been conducted during 2003, 7 and 2012. The NCLP's guideline 2003 clearly states that the mainstreaming of children in NCLP schools has to be done within a maximum period of 3 years. Thus, NCLP schools running beyond 3 years is in violation of NCLP guideline. However, it is found that NCLP schools were running during 2003 to 2006, 2007 to 2010, 2011 to 2013. For the years 2006 and 2010, no justification has been found as to why NCLP schools were running beyond the maximum period of 3 years and which beneficiaries were enrolled in the said schools. No sanction of this ministry for running the NCLP society and STCs in 2006 and 2010 was given. The grant released during the year 2006 and 2010 was of rupees 52,69,500 and rupees 34,85,300 respectively. It is requested that the details of the children enrolled in the STCs during 2006 to 7, 11, 10 to 11 and the basis, that is survey report, for enrolling the beneficiaries during these years be furnished.
Beyond 3 years, sir.
Yes, ma'am.
You give those, you furnish those required material, we will do the needful.
Yes, ma'am. Yes.
You have said that.
Yes, ma'am.
Why? What did you do? They have sought for these details of these things.
Yes.
Where is your response to that? You can't straightway say, because you have put both mongoose and cobra together in this letter. One line, one side, you say it is time barred. Other side say we can take the and keep it. Others, he say we have to take the sanction from the chairman. If you furnish entire material to show that they have worked beyond this particular period, we will consider. Unless he wants to pollute this view by his argument.
Thereafter, next paragraph.
All right, read.
Consequent to the submission of NCLP scheme into SSA of Ministry of Education, this ministry by letter dated 14/3/2022 requested all the district project society to submit their liability claims. Letter was issued on 14/3/2022, madam.
Correct.
By the ministry. To submit their liability claim, if any, in prescribed format by 31/3/2022, what I have earlier submitted. This ministry issued another letter 21/10/2022 again request the claim in prescribed format with supporting documents with the deadline of 30/11/2022. In the said communication, it was clearly mentioned that claims or information received in the ministry after 30/11/2022 will not be considered for processing. No claim was received from NCLP Cuttack. It is requested that claim of liability be submitted in the prescribed liability format with proper justification for delay. The details of beneficiaries and staff volunteers along with their...
You are telling even if delayed claims are furnished, if you furnish the explanation for that, we let it is.
No
deadline there. Nobody is dead. You have kept everything alive. You say, in the first paragraph, you say cut off date. Then you say, if there is delay and explanation is offered, they will be considered. Then how can you resist the writ petition on the ground of delay alone? Because you have said to the collector, not only collector, to all the secretaries, perhaps of the states.
This is relating to collector.
This collector.
Yes.
This collector only.
Yes.
You have said, you submit the proposals within the cutoff date. If there is delay, let them furnish the explanation. We will consider. And you also said that you will take the sanction of the chairman. Then how can you resist the writ petition?
No, I am not resisting. I mean, what is the fact I am submitting?
No. Resist means how can you oppose the writ petition? I cannot teach English also. I have to be very careful in choosing my English words from the vocabulary. Because most of the words which I use are ununderstandable, unfortunately. I said resist writ petition means oppose writ petition. It is another word which Apex Court uses, unfortunately. you have said cutoff date is 31/3/22, 23.
31/3/2022, which was extended to 31st November 2022.
That is then extended. Then you said even claims made belatedly, we will consider if there is a plausible explanation. Then how can you seek a dismissal of the writ petition? I'll change my terminology. How can you seek dismissal of the writ petition, rejection of the writ petition on the ground that the petition is belated? Where is the belated petition? If the petition was filed, when did you file that petition?
In this paragraph, it was also clearly mentioned. 30/11/2020.
22.
That is the last cut-off date. Thereafter, no claim will be considered.
No claim will be considered. Which letter?
See, 87 page, annexure C3.
The best way is now, therefore, this judgment can be written this way, that way, depending upon the circus of the language. But now, what is the explanation you have offered pursuant to this? Where is your...
My lords, my submission before...
is delayed, that's all.
That
you are repeating that, I have understood.
Apart from that, my lords, his claim, basis of the claim is not explained in the writ petition.
That is not your case in your reply, in your letter to the Union government.
My lords,
writ petition is one part. We know with the pleadings, rules of pleadings are not strictly applicable.
There should be documents to that effect, my lords.
No, he has produced the letter.
Nothing, my lord. Yes.
No, that
my lords, I have a claim. That should be a basis for the claim, my lords.
You only have recommended for him.
My lords, recommendation doesn't spell out his claim, my lord.
NSR 1 and NSR 2.
My lords, can you see that it is not that he is entitled to this much of money. That can be determined only, your lordship may relegate to civil court. It will be adjudicated.
For another 10 years, you will fight in the civil court.
NSR 1 is about by limitation.
No, that I don't agree with that.
And 1 and 2 is NSR 1 and 2 is my engagement.
Your client has said,
my lords, that will not extend, my lords. My humble submission.
Extension. You said...
Unless there is exclusion, my lords, limitation squarely runs, my lords, from the date of cause of action, my lords.
No. Sorry.
My lords, I have one judgment, my lords.
There are, see, you can't just simply... I will look into that judgment. It's another thing. But what we have been taught in the law school is the limitation aspect is very amorphous it is. You can't say this is time barred, this is not time barred. That cut and dry idea.
My lords knows the settled principle of law is that if uncontroverted petition discloses limitation, it should be...
Apex court say, which Rustumji on limitation, a very good book on law of limitation, Rustumji, and there is another D.A. Desai. They are very good, they are considered to be good books by Supreme Court. Rustumji says, you can't decide a limitation period by just seeing the calendar. A host of other factors enter the fray.
Mixed question of facts and law. But here, my lords, admitting the writ petition as true, my lords, there is a clear case of limitation.
Where is the limitation?
My lords, paragraph 4.
No, you can't read one sentence from the pleadings that way.
No, entire para.
Entire para itself. We can't construe...
There is no facts involved, my lord.
No,
disputed facts.
You admitted, man. You read, whatever should be done. I will remit this matter to your portal. Take all necessary particulars from the petitioner. You furnish it to the central government. Central government should consider it in the light of the letter dated 29 January 2024. Brother, though that letter is sent in response to the petition, writ petition, still there is something which you can make use of either way. Let there be due consideration of claim of the petitioner.
My lords, that
In
is
terms
what
of this one. You know civil court, brother.
My lord,
It will
what
not
I
change.
say, he has to substantiate his claim by filing
That he will
documents.
do. No, that is not your case, sir. Your case is you are not substantiating your claim. Therefore, I am not recommending it to the central government. That is not your case. You have recommended his case.
My lords, that is not.
I will keep open all contention so that you can have a fresh decision on.
Lordship, my engagement is clear. And it's one.
You can't. You want to go to civil court?
No, no, my lord.
Your state is opposing your claim justifiably that way. But anyway, because there is some material to show that you have done something. In all these petitions, same contention.
Same concern, but in so far as WPC number, my lord, in last three WPC, that is WPC number 26890,
26890,
and 26964, and 26981. WPC 26981.
Last three.
26891, 26890, 26694, and 26981.
26981.
My lord.
Yes, last three.
Here, my lord, the case is to take slight different because initially the petition approached this honorable court, and this honorable court directed to consider the representation. My representation was considered on the ground that since document is not traceable. On 9/8/2024, they have rejected my representation. That is, the document is not traceable. That's why my claim cannot be decided.
Who rejected it?
My lord, that is the page.
No, who rejected?
The state government.
State government rejected.
My lord.
You make a fresh claim.
Yes, my lord. All the matters passed in my lord, my lord.
Fresh claim.
My lord.
Within 4 weeks.
My lord.
Then submit it to the district collector.
Yes, my lord.
Who is the window agency.
Yes, my lord.
Window agency will examine everything.
My lord.
Then it shall recommend or non-recommend your case to the union.
My lord.
Union government will take a fair decision.
Yes, my lord.
Keeping in view all aspects of the matter, and also it's a letter dated 29/1/2024.
Yes.
And 3 letters, 14/3/2022, 31/3/2022, 21/10/2022.
Yes,
that will do justice to you.
Yes.
It may give a fresh cause of action for waging another round of legal battle.
Yes, ma'am.
So that by that time, you will become the senior advocate, if not judge at this High Court. Take down. Kindly be seated. Kindly mistake me because I have to do justice. I should know what is the case of the parties. I can't send litigants back saying that your lawyer has not properly argued. That is not my object. The object of the Constitutional Court is to do justice to the litigant. For that, I am not only a judge. It's a participatory process. It involves everybody. Then I have to find out. Otherwise, saying some jurisprudence is barred by limitation, go home. That will not do justice. That's not the object for which writ jurisdiction is founded. Can be seated? Basantpu. Please, Basantpu. Can I say like that?
Yes.
Yes. All these petitions have substantially similar fact matrix. Come on. The variations this side and that side little, come on, notwithstanding. First, essentially the claim is for money. First, this is in the nature of reimbursement which the petitioner agencies have claimed on the ground that while discharging certain functions under a central government scheme, they are entitled to put forth the claims which essentially the district collector has to process, keeping in view the policy parameters. First of all. it hardly needs to be stated that the state is the implementing agency of the scheme in question, the same having been funded by the central government. First, a bare perusal of the contents of the scheme shows that it is intended to bring the children to the mainstream of education with the involvement of agencies like the petitioners. First of all, for that, formally contracts are concluded between the agencies and the implementer, that is essentially the district collector, through whom the state functions in implementing the scheme in question. First, next one. Learned counsel for the petitioner vehemently argues that under the contracts in question, the obligations having been discharged, the petitioners are entitled to payments which they have specified in their claims. Semicolon. The district collector has recommended substantially the claim of these agencies, and there is no positive response from the union government to the same. First of all, therefore, is submit the interference of the writ court is eminently warranted in the matter. Next paragraph. After service of notice, the union government has entered appearance through its CGC, Senior Panel Council, by filing the counter, in substance repelling claim of the petitioners. First of all, the state is represented by AGA, and it has chosen not to file any counter. First of all, learned panel counsel appearing for the union government vehemently opposes the petitions, contending that, column, in front of them, just one writing. The petitions are time-barred. 7. Even for instituting money suits, there is a specified limitation period of 3 years. So, although the Limitation Act is not, Act 1963 is per se, per se is not applicable. The apex court has taken the view, more often than not, that while adjudging laches and delay and laches, regard should be had to what has been specified as limitation periods in the 1963 Act. Semicolon. Even otherwise, there is no privity of contract between the petitioners and the union government. First, lastly, he contends that the claim under the scheme in question has to be time bound by its very nature. Semicolon. Evidentiary substantiation of the claim has also to be undertaken. The so-called contracts which the petitioners are alleged to have entered into with the state agencies are themselves time-barred, and they trampled the timelines prescribed by the central government. Therefore, no legally enforceable liability does exist on the shoulder of central government. First, if any mistake is committed in the sense of exceeding the parameters of the scheme in question, it is for the parties to work out their remedies elsewhere. First. Next paragraph. Learned AGA appearing for the state OPs with equal vehemence resisted the petitions, drawing attention of the court to the parts of petition pleadings that demonstrably petitioners apostrophe claims are hopelessly time-barred. Under Section 3 of the 1963 Act, a duty is cast on the court to reject the time-barred petitions whether such a contention is taken up or not by the opposing parties. True it is that the state has not filed its counter, but it can show that the petitions are either not maintainable or that they are otherwise time-barred. First, he also mentions about the district collector's letter dated 13/4/23. District collector's letter 13/7/2023 saying that a dead cause of action cannot be revived by acknowledgement or the like. The limitation period runs once the cause accrues. Even otherwise, the contents of the letter dated 13/7/2023 addressed to the director, addressed to the central government, would not advance case of the petitioners in any way, material particulars militantly lacking. First off. Lastly, he contends that the petitions involve disputed facts, and therefore the petitioner having alternate and equally efficacious remedy of suit should be non-suited here. First, so contending, he seeks dismissal of the petitions. Next. Having heard the learned counsel from the parties, having perused the petition papers, this court is inclined to grant marginal interference as under and for the following reasons. One, the central government scheme, it is broadly admitted at the bar, is not a statutory scheme as such, although some of the paragraphs therein loosely refer to laws relating to protection of children and advancement of children's interest, educational interest. First, essentially, it is a scheme promulgated in exercise of executive power availing to the union government under Article 71, 70, which is that 162 is state. Corresponding article for the center is what? So and so of the Constitution of India. The apex court in Sahib Ramjawaya Kapoor versus State of Punjab observed that the power of the executive power of the government stroke state is coextensive with the legislative power. That is how the scheme of distribution of legislative and executive power is enacted in the Constitution. First, where schemes of the kind are kept in view in catering to the educational needs of inter alia children, it cannot be argued that its provisions are not justiciable. First, that is how Ramjawaya judgment is structured. Where parties envisaged under the scheme undertake certain obligations by way of contract or otherwise, they are entitled to draw the benefits of the scheme. First off, therefore, the contention that scheme is non-statutory or otherwise would much pale into insignificance. In any way, it cannot be considered as the China wall that would prevent the citizen from gaining entry to the portals of constitutional courts. Ram Javaya, 19. Where is citation, brother? Take out that citation. 50, so Justice B.K. Mukherjee's judgment. 73, Article 73. Stroke 162. 162. Give that citation of Ram Javaya. Next point. The vehement contention of learned panel counsel and learned EGA that the claim raised in the petition is time-barred need not be deeply examined by this court in as much as it is a mixed question of law and facts, and that the factual situation has to be ascertained by the district collector after looking into the records. First, that is how the writ courts in the country function under the Constitution. That being said, a genuine claim cannot be negative by just saying that the claim is time-barred. That would not augur well to a welfare state constitutionally ordained. Therefore, this aspect of the matter, in the view of this court, is kept open for consideration at the hands of district collector in the light of what is observed hereinafter. First. Next paragraph. One more sentence you can have. For taking this view, support is gained from the text and the context of collector's letter dated 13/7/2023 and central government's letters dated. 3 letters you have mentioned. Yes. Which are those letters?
It is 29 January.
2024, comma,
and
sit down and answer. This is not a pregnancy.
Letter dated 14/3/2022.
14/3/2022.
And 21/10/2022.
21/10/22. 21/10/2020. First. The one of the letters which learned panel counsel very vociferously read out to adumbrate his stand would show that the timelines are not static nor inflexible. First off, it is specifically stated in one such letter that if claims are put forth after broken delay, comma, the authorities may consider the same if there is a plausible explanation, therefore, and if the same is sanctioned by some higher authority. Chairman is there. Chairman, you read that word, na? Chairman of the There is no, the word chairman, you read sanction of chairman, something like that you read, na?
Chairman is the collector, no?
You,
the chairman.
the word chairman, I remember, he read it out.
There is preceding paragraph. So far as village concerned, there is no sanction.
No, that paragraph
Chairman,
is related with the last paragraph. Word chairman is there in that letter.
Yes.
Namely, the chairman of what it is?
Chairman of NCLP.
Chairman of NCLT. NCLP.
Yes.
First
LP.
How big it is? Next one. The vehement submission of learned EGA that there is enormous, that the petitions are hopelessly time barred and therefore consistent with the statutory duty under Section 3 of the 1963 Act, this court should negative the same, does not much impress the court. Kindly give that decision which you banked upon. As already mentioned above, there is a C difference which a blind man can see between the doctrine of delay and laches and the principle of limitation. First off, limitation is a factor left to the domain of the legislature. To that. Delay and laches are ordinarily in the domain of the judicial institution. Decisions of the apex court in this connection galore in the law reports. First of all, his heavy reliance on Surjit Singh Sahani versus State of UP 2022 15 SCC 536 would not much come to the rescue of his clients, more particularly because the collector, district collector, himself had addressed a letter dated 13/7/2023, that is correct? Recommending in a way the case of petitioners. Although the names of petitioners do not much figure. First off, some doubts relating to the contents and the meaning and content of these letters were raised at the bar. First off, those doubts do not have, are nothing but the stilts, the nonsense on the stilts, to say the least. In view of the collective view emerging, in view of the collective stand of the central government emerging from the three letters mentioned above. First off, if there was any doubt, the clarification could have had by the central government by addressing the district collector. First, that having not been demonstrably done, such a vague plea cannot be entertained. Full stop. All the above, next one. All the above being said, learned counsel for the petitioner is more than justified in submitting that his clients should not be relegated to the civil court at once, when they did not have a fair treatment at the hands of answering OPs. First, the state and its instrumentalities under Article 12 of the Constitution are expected to conduct themselves as model litigants, as observed by the apex court in the case of so and so. My notes to put them. A worthy cause of a citizen cannot be turned down by the courts by quoting some jurisprudential theories. First, courts are not a happy place where litigants would throng out of joy. First, they come here with no joy in heart and left with no alternative. First, the constitutional court has to be assured of the position it takes that of the same. First, at the same time, this court cannot undertake a deeper examination of the claims as if it is the designated authority under the scheme in question. First off, added, the record of the case does not have complete facts and figures on the basis of which a decision could be made by this court itself. Even otherwise. First off. Next paragraph. In the above circumstances, these petitions are allowed in part. Semicolon. The writ of certiorari issues quashing the impugned orders in WP number, last 3. Sorry. Matter is remitted for consideration afresh at the hands of district collector, keeping open all contentions of the parties. First, in the fitness of things, petitioner may submit a duplicate claim, duplicate papers of the claim, along with all evidentiary material to facilitate their due consideration at the hands of district collector. First off, the district collector within 4 weeks from this day, recount from this day. First off, the district collector, after ascertaining all factuals, make appropriate report for recommendation to the central government for consideration at its hand within 8 weeks. First off, the central government may solicit any information or documents from the side of implementing agencies and also from the petitioners if need be. First off. However, a final decision has to be taken within 3 months from the date the district collector submits the recommendation for report. Proceedings. Web copy to be acted upon. A little linguistic changes it may undergo when I go back to the chamber. Okay. I have kept all contentions. I have waited.
My lord, my only one that last 3 matters, the collector is different, my lord.
The jurisdictional collector. Yes.
Item 70.
70. Yeah, you mentioned it, na? That Jagannath, Lord Jagannath's temple. Yes.
Item 70.
May I please, Your Lords? My Lord, in this case, the present petitioner, the president and secretary of this Bhograi Adhyatmika Mahotsav Committee, my Lord. That is a registered, my Lord, in Annexure 1, running page 10, my Lord. That organization performing the religious function of the 32 Jagannath base, my Lord.
What is your prayer?
My prayer is, my Lord, taking the permission of the sub-collector, the Annexure 4 series, my Lord. Let me submit, my Lord. Your Lordship kindly peruse Annexure 4 series, my Lord. Running page 78. Your Lordship got it, my Lord?
No.
78, my Lord.
78.
My Lord.
Yeah.
Running page 4 series, my Lord.
What is this?
My Lord, that is the recent application which is filing by our organization on dated 17/9/2025, my Lord.
Representation.
Yes, my Lord. Thereafter, my Lord.
One second. I have not understood. Representation is
for the taking permission.
Permission for what?
For the staging, making of the fire permission, and finally, the sub-collector, the opposite party, number, my Lord, 2, that is he has got provide the permission for the performing of this program, my Lord. Sub-collector, opposite party 2.
Performing of what program?
My Lord, center 32 base of Sri Jagannath, Lord Jagannath. What happened? The culture of the Jagannath enter total 32 beso. That beso performing by this organization of different area. In this area, that organization also follow the entire culture of the Jagannath Sanskriti, my Lord. The religious organization, my Lord. And
when they argue, you also disturb them that way. You disturb Das and Das's neighbor when they argue. Yeah, they will know.
Not, I am not disturbed.
No, I am disturbed by seeing that. This is a court hall. Should be like a temple. You call it as temple of justice.
Yes,
and you do all playing cards there. What will happen to the temple of sanctity?
I am not.
Which is and you also.
Anyway, what happened, my Lord? That organization is performing 2 years. In 2023, they are performing this program in this area and this scheduled land, my Lord. In 2024 also, in Annexure 2 series, the memo number, your Lordship kindly peruse, the Annexure 3, memo number 406.
G, what is the case?
My Lord.
1 second. I'll have some clarity. Because you are your opponent, na?
Yes,
you will speak in a gist, otherwise you will confuse me.
Yes, 1 minute. Your Lordship got it, page 80. 80, my Lord. That is the last letter. After receiving the permission application, our organization, the sub-collector issued this letter, my Lord, to the superintendent of police, to the Tahsildar Bhograi, to the assistant electoral inspector Bhograi, the station fire office Bhograi. Permission for the staging of Adhyatmika Mahotsav for Sri Jagannath 32 base. Sir, with the reference
32 Besa.
Besa, my Lord, Jagannath, every base 1 on Besa means different culture of the Jagannath. Culture is different dresses.
Attires.
Yes.
Attires.
Okay. Yes, madam. With reference to the application, the Tapas Chandra.
So that one is that Sona Besa. Therefore, Sona
Yes, madam.
Okay.
Different bases, madam. Sona Besi is one of the bases of this Jagannath.
Yeah, right. I understood.
So objection certificate from the Superintendent of Police, Baleswar, regarding law and order of situation. Port of the Tahsildar Bhogarai and RI concerned with the sketch map area coverage for the purpose of the staging with the khata number so and so area so and so.
Want actually,
my lord. In this case, my lord, after getting the application for the permission, providing the permission for the performing of this most of my lord, sub-collector instructed us, means opposite party 2, instructed us, you got the no objection certificate from this department.
Okay.
Means Superintendent of Police,
Tahsildar, Assistant Electrical Inspector,
yes, my lord.
Station Fire Officer.
My lord. In the meantime, my lord, after that, my lord, your lordship kindly peruse the additional affidavit. Additional 1 minute.
1 minute.
Yes.
Should take.
Yes.
This Pesa
is
apabhramsha of Sanskrit word Vesha.
Right.
Vesh.
Yes.
That way it is structured.
Yes.
Okay.
Yes. That is the.
So for this, you need permission from these 4 officials.
Yes, my lord.
You applied for that.
Yes, my lord. Applied and got it. Some permission.
You got also.
Yes, something. Yes.
Give that.
Some of the officer provide, and our date already scheduled for the 14, my lord. Card already published, my lord.
Okay. What is this terms and conditions?
No in the meantime, my lord, what happened? The administrative done part wrong, my lord. They are providing to permission to another organization.
Now the problem comes.
Your case is that after getting our application, my lord, as per the instruction, we have fulfilled all the criteria. In which way the administrator has done this. So that's why, my lord, I will coming this honorable court before your lordship, my lord.
Now Now he told the truth. In fact,
I have already submitted in the affidavit.
Yes.
What wrong the administration has done, my lord, after getting the application from our organization, thereafter instructed us to got the permission from the different different department, my lord. In the meantime, they have passed another order, my lord. Because our card already published and we invited all the peoples. That is hampering for the religious peoples of the general public, my lord.
Understood. 1 second. Well, which others they have called?
Yes, my lord. Page 80 on dated 17/9/2025.
Page number?
80, my lord.
80?
Yes, my lord.
What it says?
It said that permission for staging after getting our application.
Which law bars it?
Yes, madam.
You are not. There are Jagannath lakhs and crores of people.
Yes.
Of Jagannath followers.
Yes, madam.
Lord Jagannath, where is the restriction on the number?
Madam?
Why you only should be given? Why not others?
Because our organization performing this program, since 2 years, that is 3 years is continuing.
It is not that when Lord Jagannath came here. It is last 3 years you have been doing it. Which law says?
By then, let me clarify, my lord. By then, the organization was one.
At that time?
At that time.
Now there are many organizations.
No. The president and secretary were divided into 2 parts now, my lord. The president is having one organization. Secretary is having
no.
There is no other office bearer.
My lord.
So that there could have been about 12 organizations from this.
My lord, president is one of the advocate in this matter. He is a president, my lord.
Maybe it is not concerned advocate or anybody else. I am concerned with the litigation, my lord, here pending before the.
How, Mr. G?
One Tapos Kumar Chandra, General Secretary of Adhyatmika Mahotsav Committee, he has applied for the period from 14/11/2025.
This is from which period to which period?
My lord,
let me have the factual.
Yes, 14 to say.
ଯଦି ଆପଣଙ୍କର ଭୁଲ ହବ ଆପଣ ତାକୁ rectify କରନ୍ତୁ।
I'll hear you also. Yes.
14/11/2025 to 23/11/25. Under plot number 1866.
So 10 days it is.
10 days. This man, my lord, the person Tapas Kumar Chandra, General Secretary of Adhyatmika Mahotsav Committee, he has applied first.
Is it whether committee is a registered organization?
Yes.
Registered organization.
Both the
Our Annexure 1 month.
My lord,
Annexure 1.
No, I want to have clarity.
Yes.
Just tell me in yes or no.
Yes.
Then you can explain.
Yes.
Is it registered?
Yes. Applied register Annexure 1.
Second. Why are you jumping like that? It is registered under which act?
Society Registration Act.
Central Act.
Yes.
State Act. Your Orissa Society Registration. Registered under which section?
1960.
1960 Act.
Yes. Act.
Orissa Society Registration Act. Therefore, the other day you said there is no State Act.
No, yes.
State Act, Central Act you said.
1961.
1861 Act.
1861. 1861. Odisha Registration Act.
State Registration Act. Just see Google. Ask Google whether Orissa has got a State Society Registration Act.
My lord, here another problem in filing this writ application is my friend could have make the Tapas Chandra, the opponent party,
as a respondent.
As a respondent. Instead,
not there.
Yes.
So in his absence, we cannot pass orders behind his back.
Exactly, my lord. The petitioner.
Brother, why can't you implead him now? I will direct you now. Instead of you making up, by that time, entire Utsav will be over. So you implead him now.
But Tapas also party.
Party is there is for the petitioner, another petitioner. You have not made him an opposite party.
No. My lord, Tapas Chandra is also a petitioner here. Petition number 2.
That's right.
Petition number 2.
He is second petitioner.
Yes. So notice cannot be gone to him opposite party.
The opposite party. He himself is the petitioner here.
Yes, ma'am.
No. Patita Pavan. Two petitioners. One is
President Secretary. But my lord, I will clarify.
1 second, let you kindly hear some doubt.
My lord,
I have to clarify.
Two organizations are there.
There are two organizations.
Yes.
No. 1 second.
One is Sri Jagannath Mahaprabhu 32 Besa Samaroh Utsav Committee. Other one is Adhyatmika Mahotsav Committee. Two committees are there.
Or before the court?
No. They have applied for.
They have applied
for two committees.
No.
One had applied for the period from 14/11/2025 to 23/11/2025.
Entire period.
Yes.
You appear for whom, brother?
Other one, my lord.
I just sit down first.
I intervene, my lord.
Sit down. You have come running here. Do you want water? No. Give water.
What?
Sit down for
my
5
lord.
minutes. Take rest.
Yes.
Don't argue when you are tired.
My lord, another organization, he has applied for the period from 26/11/2025 to 5/12/2025.
You said the entire episode will be 14/11/25 to 23/11.
Right, my lord. That is one organization.
One organization.
Another organization.
It goes on how long?
10-15 days.
10-15 days.
So I suggest, my lord.
Let them apportion.
No. If these people are very much interested in Jagannath culture, my lord, let them have that Mahotsav 5 kilometers or 10 kilometers away from this place so that it can be done successfully. And I shall ask them to provide you all facilities, government facilities.
But it's Let me explain, Madam. In Annexure 1, the Tapas Acharya is the secretary. He is also applicant. And
they are saying you do it.
Yes.
Why there only?
Why there?
God is Paramatma is Sarvantaryami.
What happened, my lord? Our half construction already done. After getting the sub-collector order, my lord.
He is your opponent. You appear for whom?
I beg your lordship. I am the other committee who has already been accorded permission. I have already construction and pendal has been
after us.
No. I am the my lord, my humble adding.
I have understood.
Adding further.
I have really understood.
Then, my lord, when this suggestion was put up, then the present petitioner withdrew, abandoned. That's the order.
Your lordship,
another place.
Let me.
I suggest another.
My lord,
I have a small argument before you.
Yes, my lord.
My argument is,
yes, my lord.
My submission is,
yes, ma'am.
Our prayer is, don't litigate much on this.
Yes.
Sit across the table.
Mahaprabhu's particularly.
Mahaprabhu will not.
Yes.
Although much of Indian law is developed by Swamiji's cases, including Keswananda Bharati.
Yes, my lord.
But this is not one such case.
Yes.
For this solution can be worked out by sitting across the table under the shadow of a tree in the court corridor, court premises.
Yes, madam.
Just sit, take name of Bhagwan, make also one or two seniors to sit with you. Nobody can take this. Because once I pass order, my other brother judges may follow it. So permanently a paternalistic approach will be established. That may not be in the good interest of the institution and tradition.
I agree.
What I suggest is sit across the table, both the sides. You are, after all, you want to celebrate Mahaprabhu.
Yes, ma'am.
Is it not? There is no difference between these two. Therefore, sit across the table, have senior tall members of the bar who are little spiritual, not legal intellectual height. That will not help in this. Sobriety, sublimeness, these things you find out. Have G and Lenka, one of them, G, Lenka or Behra, any one of them you can have. Sit across the table, work out your remedy. I will make an order to facilitate this. Tomorrow you should all sit there under the shadow of my order.
Yes. What happened, my lord? Our date is in 14th.
All these things.
14 to 23.
Instead of making me decide this matter that way, I will decide. You are brought here. Judge has no option than to decide the matter. It is his duty, which I will do.
Yes.
But before that, I am invoking section 89 of the CPC. Judge has got power.
Yes.
There are elements of settlement. I am exploring it. Morning 10:30.
Yes.
Tomorrow I am calling this matter.
Yes.
10 o'clock you all sit together.
Yes.
Come out with some solution.
Yeah. But, my lord, I agree with this proposal. I will give this suggestion for the president and secretary.
Correct.
But my lord, application filed by the secretary, and also after getting the order of the sub-collector, they are busy for the permission. In the meantime, they pass another order to another organization. That is the illegality.
No problem.
Obliged.
But you sit together.
Yes, ma'am.
Then if you come with an amicable settlement, I will make it rule of the court.
Yes.
Under section 89, I have that power.
Yes, ma'am. Yes.
89 of CPC is extended to high courts also by the apex court now. So most of our disputes can be solved by sitting across the table with clean heart, clean mind, clean head. In Supreme Court said, litigant should approach the court with clean head, clean heart, clean hands. That way you sit across the table and pray Jagannath, Lord Jagannath. Give some good thing. That's how our mantras are. Dhiyo yonaha prachodayat. Let our intellect be endued in that direction. That's the meaning. Dhiyo yonaha prachodayat. You enact good thoughts in me. You sit that way. Morning I am calling this matter. All right. And hopefully you will come with some settlement. Before going there, just do not go there to satisfy ego of the judge. I have no ego here. I tell you, you go there and sit, work out your remedy. If possible, have a tall person who is agreeable to all of you. One person you can have from the bar, maybe from the bench also. Only thing is that judge will not sit for hearing this matter. He can be disabled himself. He can disable himself. Some judge, bar, office bearers of the bar. Some great tall Swamiji saints are there in this city. This is a sacred city, Cuttack. Is it? Or you dispute that? No, you don't dispute that. Do you dispute that? Tomorrow itself it should happen. Because 13,
Yes,
8 is 13, 14.
14.
14.
Well, if in that area,
our suggestion you are putting. Yes.
in our time,
Suggesting
our
another place.
our time
Another
is
place you select.
our time.
Another place.
Another place you select, which is beyond 7 or 8 kilometers away from this spot.
That's
I will advise
In
them.
this area, that
government is offering.
that area is not available in only this.
Yes, government is.
Government is saying we are making available.
Yes, government will.
My lord, the president is also present.
President will do it. They are saying no.
Yes.
They are saying, yes, you do that. Who will oppose all these things in this country? Nobody will oppose it.
My lord,
Only is subject to maintenance of law and order.
Yes.
Maintaining of
That becomes easier.
because if they are playing in hide and seek, because the other permission in electric department, all fire, that will take more time, my lord. Because
everything will be organized.
Because what happened, my lord? Let me finish. Your picture is not true. Let me finish. Because our application filed on dated 79/2025, my lord. Thereafter, the sub-collector director on 17. But in the meantime, so many days already passed. That is not possible to got the enter permission till we have got it.
Those permissions
within 3-4 days. How is it possible, madam?
No, we'll direct them now. We'll call the office. Once you arrive at an amicable settlement, I will direct the jurisdictional officers to grant those permissions.
Yes.
What's your answer?
Eschewing this matter.
Because our card already, for your lordship, I have filed affidavit, my lord. Listen, and because your lordship kindly fill our card, my lord.
How much money you have spent for that card?
Card and other 10, my lord. Your lordship kindly peruse the photograph also. 10 photograph.
All the permission there.
Because your sub-collector already directed. Your sub-collector, you see your letter.
We're not doing WhatsApp.
No. That is your sub-collector letter, my lord.
No,
After this letter, then we have arranged all the things.
What is that?
That is there. I am not telling you, my lord.
You have not built their Taj Mahal. You have only the stages are built for that. Nah. Those that you can do if you decide it in the morning. Don't take ego trips, especially afternoon.
Therefore, Lordship,
litigants be that way. The court and counsel should not take ego trip at all. We should decide the matters fairly. This place is not for settling the personal scores here. Nothing like that. I'm telling it to you also.
Yes, that's right.
Your client should not take it very fairly. The government is coming with a proposal.
I'm suggesting that you select a place which I will facilitate you. Maintaining of law and order, fire, whatever it is.
Everything will be organized.
Because their program is 26. But our is 14.
You have applied little earlier.
14, my lord. What happened, my lord?
Do you have objection whether there is conflicting they overlap?
No, only, my lord, in pursuant to permission, we have already started infrastructure and
What
Pendal. Yes, Pendal. I showed the photograph. The statues. So many things we have already installed. Therefore, my lord, yes, sorry.
What kind of communication skills I do not.
Yes, sorry.
Pendal is put now.
Yes, already.
Who is there in the Pendal place?
Video.
Take out video. I want to see that.
Lordship, permit me then.
Take, no problem. How big the Pendal is? Let us see.
Yes, sir. Details are.
If you build Taj Mahal, I can understand. That built Taj Mahal.
No,
Pendal is.
Yes, no
question of
substantial
bamboos and big cloth. That all.
Substantial. Sorry, my lord. I was trying to get the photocopy.
That all. Then we'll see that. This is photograph.
What you have done with it? Yes, my lord. Our photograph I have already filed my affidavit.
How big it? I will constitute the committee now.
Yes, my lord.
With the 10 members of the association.
Yes, ma'am.
Of them, 3 will be women, 2 from the government side, and remaining from the part, including you people. You decide all these things and report compliance to me.
Because I have already submitted all photograph, my lord.
It's all.
How come?
Tell you.
After your lordship interference, my lord, they have given the permission to other party.
No problem.
So the government council stated that there 2 group because our secretary also applied, and that is the date of 14/2/23. Our application.
When government is saying to provide, my lord, why is it?
Because there is no place, my lord.
See,
government will give, my lord.
My lord, this locality, my lord, you don't know the area, my lord. Because my brother is in this. Government. That's his problem. But this locality in this president of this, there is no area for this one organization, my lord.
Within beyond 5 kilometers, there is no space.
No space, my lord, is stated. No space, my lord.
If there is no space, then we can allow you.
Outside they are giving the space. Otherwise, I am dismissing the petition.
Yes.
Because there is no legal bar for entertaining other applicants.
Yes, my lord.
I have to dismiss the petition. All right. Instead of that.
Now, what illegality done, my lord? I have expressed, my lord.
No, you have argued.
If your lordship
you have very impressively argued everything. But in that famous book, Idea of Justice, by Amartya Sen, he has given patterns as to how adjudication should take place. He has given an example of Lord Krishna's flute. If there are multiple claimants, how it should be organized.
Yes, ma'am.
He wrote that book in contradistinction to John Rawls' Fairness and Justice.
Yes, ma'am.
So John Rawls teacher, student also. That I am just thinking that way. Because it's after all, both you are doing laudable work only. Is it? Who will oppose these things? But both cannot occupy the same place at the same time.
Not same time.
No, only 3 days.
3 days.
Our program is 14/2/23.
Where will
their program is 26/2.
Where is the conflict then?
No. 3 days. 3 days. It is not possible. They will, my lord, they will vacate the premises. And these people will again constitute the tents, etc.
If your lordship director, they would vacate because our card already published, my lord. Our application is first time. Yes, all the things is
Location differs.
Mr.
We will vacate in 23 night.
If
want to take my lord.
1 second, sir. Please, 1 second. Permit me to think. Yes. What I suggest is,
my lord,
there is no overlapping as such.
No
overlapping. So one particular period, which I did in the case of Raghavendra Swami Mutt versus the other Mutt, Uttaradi Mutt case, 2000 into Supreme Court, 2016-17 Supreme. Just take out that judgment. It is, if same place, same time, then Udupi model, Paryaya.
Yeah.
1 year these people, 1 other year other people, that way. If slots are available,
yes,
then 1 slot to these people, another slot to those people. That way, and it came to be affirmed by the Supreme Court. they wanted to do puja. It is 3 days.
Yes.
So what I did was 1.5 days for this mutt and the remaining 1.5 days for the other mutt.
Yes.
That worked there.
Yes.
That has been working there.
Yes.
We can adopt the same model here. The period, since there is no much difficulty because there is no overlapping of the period.
No overlapping.
No overlapping.
There is no overlapping.
Then where is the problem?
Problem is the same bishop, Jagannath bishop will be done by one group. The same bishop will be done by another group.
Where is the prohibition?
So, my lord, there is no prohibition. The crowd will not come here.
No, if they do not come, they do not come.
That is with the
Another problem, my lord.
Complete that. You have to resist your temptation.
And who will pay this?
For you.
Second one will not.
What do you say? You may not be the crowd puller if that happens. That's one aspect which you should consider.
Yes.
What I suggest is 14/11/25 to 17/11/25. 14, 15, 16, 16/11/25. 3 days they will do.
Yes, madam.
The rest of the days you do.
Yes.
But,
I am agree in this.
we have already now they have constructed the pandal and the statue we have given. So this shall be dismantled.
No, don't dismantle that. You use that their pandal also.
Yes.
And thereafter, you also should not dismantle your pandal.
Yes, madam.
You use their pandal.
Yes, madam. Yes, sir. Yes. That is
But the only thing is, nobody should go there with lathi.
Yes, madam.
That you
Then peacefully you should go.
And my lord, the statue we have installed, they will also take care of them.
Yes, madam.
Is that
They should
undertaking?
not be.
Yes. That will give the undertaking.
They should not
Because
be.
that is all religion things, madam.
There should not be desecration of the place, desecration of the performances.
Yes.
Place and performance. Because very sacred place.
Yes.
Okay.
That understanding, my lord. Honestly, they will not.
Mr. G, where is it? They have settled the issue now.
Yes.
I file a joint memo.
Yes, madam.
File joint memo.
Right, is undertake that.
Yes, I will undertake.
Their committee, yes.
Both you sit down. Keep your ego beside.
No, madam.
Tomorrow,
Memo.
we'll put an affidavit tomorrow.
No. Tomorrow. Right now, very insufficient.
Yes, ma'am.
Because once time is given, many ghosts will come, enter into our head and start playing with us.
Yes, madam.
Therefore, Shubhasya Tigra.
I
will agree with your lordship.
Yes, kindly come with the draft. There is one concept, na? Shubhasya Shighram.
Yes, ma'am.
That is auspicious will be done immediately.
But how many
Go and
days
bring
the
it.
function will continue?
Good evening, Commander.
14, 15, 16, 3 days yours.
Yes.
And the remaining days are yours.
Yes.
And you should not dismantle your structure.
Yes.
They should not dismantle their structure.
16 million.
Yes.
We have the talent.
Obligement.
Giant memo.
You are upgrading them, they do not.
Yes.
File giant.
Yes.
Obligement. Today, just now.
Today you file it, you bring it. I will be sitting here for 125 days.
Lord,
Lord,
my lord, yes.
Forward.
My friend's committee should undertake all the expenditure we have for Spain. They will take it because already.
Even whatever infrastructure you have installed, you take them back. They will take theirs. You take yours.
They have not done. We have already done. They will utilize our infrastructure.
Brother, why can't you do that? That's a good proposal.
Yes,
you can make use of their own infrastructure. It's a gracious gesture.
Yes.
Which you
I have already
consider.
No.
constructed
They will
That also make use of their structure also.
Yes.
You pay for that instead of re-erecting everything.
Yes.
Pay for that also. Share.
Yes.
Share it.
Yes.
Go and bring memo.
14, 16, 17, 18.
Yes. No, not 18. 14, 15, 16.
Yes.
17.
Yes.
16 alone.
No, here 25th.
You must see afterwards.
25.
Not 23rd.
7 days.
Only
Yes.
our headache is that if they utilize, they may dismantle bear the cost. Once
They are agreed.
Yes.
But everything is online. People are also seeing. They will appreciate you. The way you have settled your dispute and report.
Oh, nice, man. I hear lordship because Lord Jagannath with you, sir.
Jagannath's issue. Therefore, I cannot. All right, you come with a memo, joint memo.
Yes, ma'am.
Right now.
Yes.
Give papers. Give them papers. Do you want pen also? We have 10 extra pens here. Draft it now and come back. And you draft it
4 o'clock. We're giving back 4 o'clock.
All right.
But I have to, I have to file a vina.
No issue. Your party in this? No, you are not.
File an intervention.
No, I'll tell them to implead it. Implead it, party. Implead it. Petitioner is permitted to array so and so as a OP number. Give that.
OP number 5.
OP number 5. I don't think the newly added OP is represented by Learned Advocate Sri. All right, bring that. We'll complete that. This also over. No issue. Take. Just show the draft to G. This moment and then finalize that.
Let them file ballot.
No, they are if again repairing and other things, because today I should decide this, because 14th they are doing it begins.
Their problem, they are solving it.
Yes. You take G with you. Yes. After a cup of tea to him. Okay. Yes.
Item 34. 33 has been adjourned.
Yes.
Item 34.
My lord, in this case, petitioners pray for direction to the opposite party to reinstate them, my lord, in obedience to the order dated 34/15, my lord, pass and 1316/12. Till that, though they have lost in the writ of appeal.
Sorry. Which is the order you want to implement?
Order dated, my lord, 30th April 2015, my lord.
30th April 2015.
15, 2015, my lord, 1.
In which case?
In WPC number 13165 of 2012.
Of 2012?
Yes, ma'am.
Where is that copy? Where is that copy in the annexer?
We have quoted it, my lord, in the order. In the petition, I have quoted it, my lord.
Do you have copy of that order with you?
Yes, please.
Give that. Since the petitioners have worked, all the benefits of the scheme should be extended to them, both junior teachers and consequences. What did you say, brother?
My lords, this is pending before Supreme Court.
Is there stay?
My lords, notice was issued. I have my lords, I have not taken instruction after the last was given in April, my lords. Let me take instruction what has happened in the meantime.
Monday. Call on Monday at the request of the DG. Okay. On Monday, you have to make a statement. Otherwise, I will direct their arrest and detention. How many years they should wait after getting the order? There is a limit.
That's 31.
Correct on Monday. Yes, next.
Item 35. Item 35.
35.
Yeah.
Here this demands of the petitioner by the opposite party number 5 file an appeal before the director against the order of termination, my lord.
Termination.
Against the order of termination.
I am for appeal number 5.
When termination happened? Already in the matter?
No, 1 week.
No, my lord.
One time, 1 week time.
You want more time?
Yes, ma'am.
All right.
Only problem, I have no objection with regard to 1 week time. The
request of
allegation was there, OP5.
Next.
Allegation is there, my opposite type sold the property of the college land.
Let us see. 2 weeks he wants, na? Yes.
Item 36 adjourned. Item 37.
Item 37. Due to non-compliance of the peremptory order, the FAO was dismissed. I have filed the same appeal. There is a delay of 1 year. So since there is a private opposite party, notice will We'll go to.
Notice has to go.
Yes, yes.
Issue.
Opposite party number 3. Government comes to 1 and 2. Notice may go to OP number 3.
Emergent notice to 3. Yes.
Along with delay.
Notice on both main matter and delay application.
Requisite by Friday.
Yeah.
My lord, counter to be filed, my lord. I will file the counter, my lord. And GA department is also the necessary party, my lord, in this case, government.
I filed the IA for implemented a party of a GA department. Already I have filed the IA, my lord. That should be allowed. I will serve the copy.
IA for
amendment of the main fiction matter.
Petitioner wanted to impede the GA department at the opposite party. Filed an IA to that extent, but also seeking amendment. Yes, maybe allowed by the
This is impleading. Impleading. Who to be impleaded?
GA department.
GA department. GA means
General Administration.
Personal grievance department represented by special.
Will allow the application. Petitioner has moved this application seeking addition of a party, namely GA department. As OP number?
OP number 4, my lord.
OP number 4.
Commissioner and Secretary?
5. 4 Secretary.
4 and 5?
4 only.
4. OP number 4. Personal. Apparently, the presence of the party would party now sought to be impleted would facilitate due adjudication of the case. First, the said party is a proper party, if not a necessary party, in the light of Rajia Begum versus so and so. Supreme Court. No prejudice will be caused to the other side, except that the cause title becomes little longer. First one. If implement not allowed, petitioner may be affected in the final adjudication. First, next, in the above circumstances, application having been favored, leave is accorded to the petitioner to implead the said department as OP number 4.
My lord, amendment
petitioner
already
filed the amendment. Have you filed the amendment?
Yes. Already
filed it here.
Yes.
The amendment filed in advance in contemplation of the leave is accepted. Okay. But you have to make some amendments.
Consolidated
cause title already filed.
But see, CPC says you have to effect amendment to the pleadings and file amended the pleadings.
Yes.
That you have done.
Yes.
You have to make rectification. Yes. Petitioner to amend the pleadings, original pleadings. Yes. Next.
Item 39.
Item 39, Lord. In this case, today you have received the international application filed by my.
Yes, brother.
Yes, brother. I have served a copy on him.
You have served on him?
Yes.
You want to file objection to that?
Yes, brother. 2 weeks time, I will verify that document.
Does it require objection?
It is
2 weeks time.
You want?
Yes.
My lord, I have already filed and a copy already served last month, my lord. They have also filed the objection. That I may be allowed for intervention.
Both the application will.
But this application was filed when?
Filed since September.
Within 1 week, file objection.
So they have filed the objection, man.
No, so it is obligation.
Yes, my lord. Your
application. We'll take up both applications.
Yes, yes. All right.
Call 2 weeks for filing objections to the IA in question. First up. Call immediately. After 2 weeks. Entry mortem is there?
Yes, my lord.
Because of the entry mortem, my lord.
No.
After 2 weeks, we'll dispose of them. Entry mortem to continue until next day topic. Yeah.
Item 40 has been adjourned. Item 41.
Yeah.
अगर किसी रिपोर्ट नहीं
Yes. If in this case the petition was selected as the Shiksha Sahayaka in the year 2008.
Make use of mic because youngsters are sitting in the court hall. They are complaining. What the lawyers argue, we do not hear it all. Though I hear.
Yes, madam.
This is a bit of classroom also where I take lessons from you.
Yes, madam. Present petitioner is selected as Shiksha Sahayaka in the year 2018, my lord.
Date?
In the gradation name placed in the gradation list.
Date. You said date, year, na? I am not on year. Calendar gives dates also.
That is 21st March 2008. My one problem is that, my lord, your lordship can see the last order, 29/4/2025. Before that, your lordship,
Brother,
matter was
Shashikant's order.
29/4, my lord. Matter was referred to the All India Institute of Medical Science for the medical test. So that report has
not come.
Very
Special medical board.
Direction is issued to the government council to produce the medical report, man.
Whether they are parties.
No, they are not parties.
Whether they are them.
Yes, as per the direction of the Honorable Court, matter was referred to the All India Institute of Medical Science. Prior to it was sent to the AC Medical College, Kotak, where given thereafter it was referred to the, because very same medical college given the two certificates. One is below 40% and another is above 40%. So
NKCG is also there.
Yes,
given
Mr. G, just ascertain why report has not yet. Whether registry has received the report. Did you undergo the examination?
Yes, my lord. Yes, ma'am.
When?
In the month of June.
June. Even then it has not come. The coordinate judge of this coordinate judge of this court by order dated 29/4/2025 had directed the medical test stroke examination of a petitioner. Petitioner. First off, counsel for the petitioner submits that the said test for examination has been accomplished on
the month of June, my lord. Particular date I don't know.
Which month?
Month of June. June 2025.
In June 2025. And submits that the report is yet to be obtained. First off, Ames, Bhubaneswar is directed to send the original report in a sealed cover to the registry of this court before the next date of hearing. First off, call this matter in the second week of December.
My lord, can I
registry to send a copy of this order to the director of Ames Bhubaneswar for compliance.
Not submit, direct to him to appear before them.
Already has appeared and examination done now.
Yes.
Already has been. In pursuance of the direction already.
Correct.
They have intimated thereafter.
Wait to send a copy of this order to the director of Ames Bhubaneswar by speed post for compliance. Non-compliance will be viewed very seriously, and director may be personally summoned to appear before the court. Yes, it will come now. Appear before the court is sufficient. They avoid court. Nobody is happy to come to court. So best way is they will be called to the courts. Yes.
Item 42 has been adjourned. Item 43.
Yes, sir.
The short grievance of the petitioner is, my lords, the petitioner appeared the examination, but its result has not been declared.
Result has not been declared.
Yes,
not announced.
Not announced.
Others the results are announced.
Just, my lords, just a short grievance is, my lords.
No, I want to know.
Others, my lords, they are not allowing me. They have not published the result.
Nobody's result is published.
No, others' results have been published, but no results have been published, my lords. The grievance of the petitioner is, my lord.
All that I understood. He has understood, I have understood.
The petitioner entered into the academic course in the year 2010.
2010,
my lord.
What is that course?
MCA course.
MCA course. MCA course.
Just I am submitting my lords, 2 to 3 lines, my lords. I have admitted in the MCA course, my lords. MCA course is, my lord, 3 years.
3-year course.
And 6 semesters are there, my lords. One is 1, 3, 5 are odd semesters, and 2, 4, 6 are the even semesters. So 6 semesters are there, odd semesters and even semesters. Odd semesters results examination will be held in the November, December. And even semesters result examination will be held in the month of April or May. And if any students fail in the both examination, the odd or even, they will appear the special examination. And the special examination will be held in the month of July or August months. That is the practice of the BPUT matters. I appeared the examination till 2016 matters. I have completed matters out of 30 papers. I have completed 24 papers matters.
Is there any timeline for completing the course?
The completing timeline matters 6 years.
6 years.
6 years.
Did you complete it within 6 years?
Then matters, just matters. Then matters that 2016, I should complete by 2016 matters. 2016 matters, in November, I was allowed to appear the examination. That is the odd examination. I appeared the examination. Result was published in 2017. 2017 matters, I filled up the form for even examination. Admit card was issued. But result was not declared.
No, they say beyond timeline, if you by mistake of the university, somebody permits you to take examination, university cannot do that because timeline is prescribed by statute.
Yes, because they have once they have allowed to examine, allowed to appear the examination.
All right, you are allowed to write examination. You are allowed. You were made to read, write everything.
And they have a
timeline is like this.
And they have published that. They have published the
judgment of the apex court.
Yes, I am submitting one line.
Maharshi Dayanand
and Maharshi Dayananda University versus there is no custom or tradition of exchanging the rulings with your friends when they appear against each other. Generally, in Bangalore bar, we do that. We when we have to argue, generally we call that advocate, or we go to him and say, "Sir, these are our rulings."
No, I have not seen this.
What to do?
But
Para 21,
my lord.
Word no is missing in the judgment of the apex court.
Yes.
Good. Correct. No is missing.
My lord. Then, my lord, paragraph 27 and 28.
Timeline is 6 years.
Yes. As per the academic regulation.
Your point is answered by para 27 specifically.
Yes.
Maybe you had argued that matter, I wish. Same points. I was permitted to take up examination. I was given the examination form. Now they cannot turn around and say, that is rejected.
I will check it.
But check. This court is not for educating people.
No,
You should be thorough with all those things.
That is principles of promissory estoppel matters.
It is not
applicable to law. Promissory estoppel, the apex court extensively considered in Khandasari Sugar Mills versus which is that Padampat Sugar Mills versus State of UP. Take out the judgment. Padampat Sugar Mills Limited versus State of UP or MP. They are against you. Your contentions are met by the apex court itself. Right off. The short grievance of the petitioner is as to non-announcement of the examination results of a 3-year course. First of all, learned counsel for the petitioner submits that his client was furnished with the examination form, he filled the one and filed it, and thereafter he was made to take up the examination, which he did. And therefore, the university is stopped from taking the stand that the results would not be announced. First off, he seeks intervention of this court. The Motilal Madampat Sugar Mills versus State of Uttar Pradesh. 79 is C. It's the 260. First off, learned counsel for the petitioner cites a ruling in support of his contention. Give that ruling. That decision.
That is decision. That is 1990 Supreme Court, my lords.
90 is no longer good law.
Yes. 1990 Supreme Court, page 1075.
That is considered in this judgment.
Jonathan Gowda versus Barampur University, my lords.
Where is that? You are not brought at all. How can I upon your memory when I cannot bank upon my own memory? Learned counsel for the petitioner seeks to gain support from the observations of the apex court in the case of
Jonathan Gowda versus Barampur University, my lords. Reported in 1990 Supreme Court, page 107.
She has to write down. Daughter has to write down. Yes, now take.
That is AR 1990 Supreme Court, page 1075.
Next paragraph. Per contra, learned panel counsel appearing for the deputy university. Yes, university opposes the petition, contending that the timeline prescribed by the university statutes for the course in question is only 3 years, 6 years.
6 years. 3 years can be extended to 6 years.
A 3 years plus a 3 years program can be at per week.
3 years plus the longest 3 more years.
No, longest 2 more years.
2 more,
5 years.
5 years, yes. 2 more years. And therefore, what has been done by the student, even with the arguable mistakes on the part of university, thereafter would pale into insignificance. First, he draws a support for this wing from the apex court decision. Delhi High Court decision. No, apex court decision. From the apex court decision.
Para 21, Mela.
No, 21 is Delhi High Court decision. Apex court decision in state of Punjab. Sorry, you take this one. The Maharshi Dayananda University versus Surjit Kaur, 2010, 11 SEC 159. First, at para 11, at para 11, it is observed by the apex court as a. Okay, I will put a flap here. Just look into and print it. Okay. Next paragraph. Having heard learned counsel for the parties and having perused the petition papers, this court is broadly in agreement with the submission advanced by the panel counsel representing the university, since the same is consistent with the law declared by the apex court in a catena of decisions, including in Maharshi so and so supra. Next paragraph. In view of the above, petition being the divide of merits is liable to be rejected, and accordingly it is, first having been made is. Next. Item 44.
I don't know my time.
Where is that amicable settlement matter, temple matter? They are ready to come. Yeah, it comes. They are ready to come. I will go back to chamber. So after they can call me. So I'll come. Okay? The rest of the matter, just allocate them depending upon the slots available.
December.
December.
69 examination.
Pardon, my lord.